Yes, Mr. Dosa, what brings you here?
Well, I beg your lordship's indulgence to move a matter. Okay.
My lord, may I mention one unlisted motion, my lord? My lord, I'll mention item number 14. I'm seeking for adjournment. I have after a week, I have to file one additional affidavit. Some important document has to be included in my petition. No, I have taken consent from the other side also.
This auxiliary workers, after the NEPA was unavailable, commercial statement.
Yes.
In under that same very rules or after the NEPA, after the state of Arunachal had come in, they were brought into grade 4 category.
Yes. Separate. Yes. That's why some notification is there. That document has to be bring in record. Yeah. After a week. Yeah. T quorum. Petitioner. Any date after a week, any date. No problem. Highly obliged.
My lordship. Lordship, I would like to mention item 11, lordship. Today's motion matter, lordship. Lordship, I want to. Well, lordship, there is defect in pleadings. Defects in pleadings, lordship. I may be allowed to withdraw, lordship. Yes, with liberty to file press. Defects in pleadings.
Sure that you want to withdraw it.
Yes, lordship. With liberty, lordship. L1, lordship.
May it please, Lordship. I'm sorry, Manor, item number 24. Manor, the hearing for the matter has to be taken up for doing. But due to affidavit in reply not shown by my petitioner, so I have taken that.
The police department.
PWG.
Department. What was the pension?
Pension.
What affidavit do you want?
Some allegation have been leveled against the petitioner, madam. Madam, I have taken the consent from the government advocate. Only for 1 week. T-zone. Obliged. Yes. Yes.
You have not submitted it. You submitted within 1 month. We direct them to Procedural.
Earlier, actually, it was taken up by senior C. Biswas.
Wait, please, lordship. My lord, this case only one issue is to be decided. Whether
the corporation should be a government.
yes, government and the dues payable to this forest corporation would be a government use.
This is everybody for it. Yes. You are a registered company. How can you become under this?
This revenue, this is a government revenue. I am collecting on behalf of the government and I am getting some share.
What is the reason of the hardship?
Correction. This is government forest product.
That's it. Government has permitted you to sell forest products. Fine.
Yes, my lord.
He has approached you. You have sold it. What profit you get, you will keep, the rest you will give it to the government.
Government, 10%.
Now, if there is something receivable from him, why does it also, how can this person be given?
Because I am functioning two type of duty. One, I'm concerned with my own
What revenue are you paying?
forest levy.
What, in what manner?
For the quota they have been allotted.
You are only in a commercial. one.
No, one of this quota, one of this is the government transaction. Because
For that, the DFO has already made a certificate. Has already got a certificate.
I am also the certificate holder.
That certificate holder subsequently you get an application that include me also.
Yes, my lord. That has not been challenged by them, my lord.
Fine, fine. Yes, before us, yes, we can. And the appellate order is neither here nor there.
No one appellate order, my lord, is concluded.
Sorry, that you are a government, you are a government, you have been informed of that.
Yes, my lord. That would be. Of the repetition.
But this will not eliminate the space of the government. This is, as a, you showed me that there is something here on record. To show that in the event they fail to do, you can collect it as an area of land revenue. Just show me. But that is basically this one.
Yes, act. Yes. By this notification number 16 to 1978, I was, one of the delegation of power has been given to me.
That is only to facilitate the transaction. Because you're dealing in things. So for dealing in things, you have to be given that information. Otherwise, you will not have that power. But will that also bring within the power to issue to recover dues under this?
My lord, they kindly appreciate what he. They are not denying that this is not a government revenue. They say, I cannot collect by virtue of capital tribunal. But this is a government due, they are also admitting. In their interpretation, my lord. Yes.
Okay, show me where is your dues highlighted.
Page 20, my lord. Paragraph 12. Of my affidavit in operation. Person number 1.
One affidavit by Mr. Vimal Kumar Singh.
Gulab Singh, sir. Gulab Singh. That's for the affidavit.
Gulab Singh. Page.
Page 201. Paragraph 12. Married now. Then we do not statement made in this entering department offers no comment. As matter devotes the report. However, the department does not admit anything which is brought out of the report. In the context of this 25 year that initial claim of rupees 1,11,71,402, which were revenue to the forest produce and forest land of reserve forest areas, were recoverable partly by the DFO Giovanni and partly by DFHCL Giovanni. For the government of the petition, which 34,93,901 by DFO Giovanni, that's one number 2, and 76,77,501.54 by DFHCL. Subsequently, an amount of rupees 48,24,198.78 was also added to the initial claim of the respondent 1 due to revised royalties, making the total claim to rupees 1 crore and 5 lakhs 1,000.
your, this is your claim. That's right. Your claim. Now, who bars you? Final solution, get it from.
In that case, I would, take the losses to Bengal public market.
Which provision?
Section two, madam, first, madam. Section three, subsection two, definition plus conditions. Bengal public demands to come. Yes, madam. Very madam. Certificate holder means the government or person in whose favor a certificate has been filed under this act, and includes any person whose name is substituted or added as granted certificate also. Now, six.
You have the right to be included as a certificate
Yes, that has been allowed.
on your application.
Yes, ma'am.
Subsequently, that was unavailable.
Madam, that issue were,
Is that, now this satisfying that you are also entitled to have a certificate under the.
yes,
There
ma'am.
should be some law. Correct. Not a government. It's a government, but it's a government, it's not wrong. You're a different aspect of.
Yes.
Now, whether this need form of repayment can also be under this act.
Madam. Madam, in that case, when it comes to this, unless forest regulation. Forest regulation.
Do you have your MOU and, or articles of association?
Madam, then I have to seek madam from the bank.
Not in the affidavit,
Is there?
Annex 3, page 41.
That is.
This is the beginning of the understanding between the government and the APFC.
Corporation.
Annex 3, page 41. Clause 3.
Affidavit of the respondent.
Affidavit of respondent number 1.
Forest corporation.
Press page 41.
This agreement.
Yes.
Yes, you are coming by way of an agreement, that is not the government.
Clause 3 also clearly.
The government. I'm
They are-
collecting
they-
revenue
they-
on
they are-
behalf of the government.
They are sharing the revenue. APFC is engaging in this forest. They are earning something, and out of that, they are just handing over only the about 15% of the share only.
Madam, this comes to how much the forest regulation is. Yes. Regulation 3, madam. Forest officer means any person appointed by.
No, your deputy manager, your deputy general manager or general manager is your name.
Yes.
This is the
Then,
Yes.
then regulation certified. Certified. Regulation certified.
Page number of this book.
38 in my.
Seventy-five, huh?
Yes, married father. All money other than fines payable to the government under this regulation or under any rule made thereunder, or on account of the price of any forest produce, or of expenses incurred in the execution of this regulation in respect of any forest produce may, if not paid when due, be recovered under the law for the time being enforced as if it were an error of land revenue. However,
Just
yes, Now, section 3, of schedule 1, public demands. What is public demand? Okay, this is under public demands. May I read, schedule 1, Yes.
So you are only making a claim to the extent of the revenue, you are not making the claim for the whole amount.
Yes,
Receivable.
because this all revenue, this money, amount is the government money. It's not my money. It's a revenue, which is, to be paid to the government.
Yes, sir.
My lord, here, it is very, very clear
Now see,
that,
the demand that they have made
yes,
of you has many facets. But what we say is that what he's trying to recover from the student certificate is only the revenue due to the government. So revenue due to the government, under the policy regulations, it is liable to be recovered as an area of damage. If that is so, why that certificate cannot be issued?
my lord, here, in their appeal also, they have classified this demand, their role into two. But I'll just. One minute. Appeal.
Appeal. He kenapa? He ngolok read peti.
The decision may be different because
Index.
Facts will be said.
Yes.
But what is more closer? Yes.
You lordship be kindly turn to page 67 of their affidavit position of the R1. Paragraph 6, page 67. There annexure 6 starts from 65. This is the appeal memo at page 67. There are 6 malad. May I read malad? It may be further be noted that the FLN corporation functions in 2 different capacities. Apart from collection of forest revenue for the government, the FLN corporation also carries on some commercial activities by its own by setting up timber and plywood industries, veneer and sawmill, etc.
That revenue, we will talk.
Yes.
But the other part, they are not correct. Right? That was, yes, so we will dispose of this matter saying that that certificate will be. They can execute that certificate only to the extent of the government.
No, my lord, here,
With regard to any other amount receivable.
here also, my lord, there will be a confusion, my lord. Because, no,
Revenue, royalty, revenue.
they have never specified which, how many,
Give me a list of the revenue
yes,
breakup.
breakup, there is no breakup.
We'll have it day after, you give us a breakup. With regard to revenue, whatever is there, we will allow this. Fine, but the other part we are not allowed. Your income from it, we are not allowed. That's a commercial. Company.
Yes, sir.
Yes,
This part we will allow. When they are not.
they themselves has admitted in their. I'll be here. My lord, some are. Yes. Well, some are very fortunate that their post-retirement benefits are ensured, but for us, there is no post-retirement. So we have to sustain our life, to sustain our retirement.
After the
Of life. Just
we'll dispose of it.
Monday, Tuesday is tomorrow.
No.
Next. Let me on 13 then.
that party. You give me the total list, amounts due, interest, whatever it is, but revenue separately, wealth separately, and then your other amounts. You put that. I don't know what to do.
Yeah, my lord. My lord, I'm appearing on behalf of HK Das, on behalf of HK Das. HK Das appearing on behalf. As per instruction, my lord, he has already given, sent notice to the petitioner to withdraw from this, this matter, my lord. My lord. But due to continuously reflection in the cost list, his name has been reflected.
My lord, I'm for respondent number 16 to 86. Yes, yes, ma'am. Yes,
Okay. You are similarly placed like them.
my lord.
You are.
My lord.
Have you? What is that in this one? You have already been evicted?
No, my lord.
Not evicted.
Not everything. My lord, so,
Not evicted without following the people.
no, that can be done, my lord. My lord, actually, in this case, my lord.
The other part of your prayer, that is pending before the Supreme Court. Supreme Court will decide.
No, that can be done, my lord. My lord.
What is the point in keeping this Supreme Court?
Yes, ma'am. My lord. That will be,
Do you are you are also in the same area where the petitioners are?
yes, my lord. I am proposing.
You inform them.
My lord.
We will take this matter on. Six maybe two,
My lord.
on 12.
12th of March.
12. You inform them.
My lord.
When if they none appears, we will close this.
My lord.
This is it for them.
My lord.
May I, my lord? My lord, I've only come here to strike out the name of, my name from the petitioner list, my lord. My lord.
None appears for the petitioners on. This one. Mr.
H. Lampu, my lord.
H. Lam,
Yes, ma'am.
H. Lam, counsel appearing for the respondents number
16 to 86, my lord.
16 to
86.
who have intervened in the matter and are similarly placed for the petitions. This court requires Mr. Lam to inform the petitioner that on the last several days, there was no appearance made on behalf of the petitioner of the matter. In the event, on the next day, that is 12/3/2024, there is no representation on behalf of the petitioner. This court will be forced to pass appropriate orders as may be called for under the petition. Mr. Babu is requested to inform the petitioners, few of the petitioners of the above position in writing. And on the next day, he shall place before this court a copy of such communication along with the endorsement of receipt by the petitioners. Right?
My lord,
You issue a notice.
okay, my lord.
Just give the communication. I was in court today, court had required me to do this matter.
My lord.
This is for your information. Otherwise, court would pass adverse orders on you.
My lord.
Right?
My lord.
So this matter is taken from 2013. And that is why I'm not.
My lord.
Otherwise, if it was something else, I would have dismissed. Right? This is matter on 12/3/2023. Right?
All right.
Please inform.
My
Otherwise, we will dismiss.
My lord.
Much obliged.
My lord, the leading advocate in this case for the petitioner is Mr. A.K. Purkayastar. Online.
It did not come. After some time, it's come.
Okay.
Yeah, yeah. Item number 4.
May I please, Your Lordship? My lord. My lord, this is service matter, my lord. The- Lordship, I'm for private respondent and
How many posts were put up for it?
my lord.
How many posts were put up for it?
My lord, altogether 9 posts.
9. How many filled up?
All 9 posts filled up.
All 9.
Filled up, my lord.
Persons who are there in that merit list.
Correct, my lord.
None from the ratings.
My
or
lord.
below.
My lord.
Your case is that the private respondent numbers.
My lord.
5, 6, 7, 8, and 9
My lord.
were picked up and then they were regularized.
Correct, my lord.
These posts should not continue.
My lord. Yes, my lord.
But one of the cases that these people were working as contingency.
Correct, my lord.
Accordingly, we have regularized.
Regularized.
As far as you are concerned, 9 posts gone, you have no grievance. You can have no grievance.
My lord.
Now, only thing is whether those private respondents were regularized in the manner.
Correct, my lord.
Who is appearing for the private respondents?
Lordship, I'm prepared.
How long have you been in service?
Lordship, I was appointed in the year 2014, Lordship,
2014.
Lordship.
contingency.
as contingency.
Now, should we,
In affidavit, my lord, it is silence.
that 2014 appointment, you can be regularized. Show me the law. Show me the position.
Lordship, as per recruitment rule, Lordship, it is 20 years. That they have to be in service for 20 years, Lordship. But then, Lordship, as per instruction from my client, Lordship, recently, Lordship, instruction that there has been a cabinet decision in regards to ex facto regularization. Lordship, recently or in the year 2021, Lordship. I filed one RTI, Lordship, seeking the information. My lord.
But these posts, they don't have sentences.
Lordship, that is admitted, Lordship, but I have a instruction. Lordship,
Say those posts will be now put up for regular appointment on regular basis. You also participate, they also participate, you will get separate.
Lordship, in that post, Lordship, as contingencies, Lordship, we are regularized subsequently, Lordship, as MPW, Lordship. We are not only the candidates.
We have only this much. We have only this much, we can't go beyond this.
This will prejudice the petition, private respondents, Lordship. Sir, Lordship, there is a cabinet decision, Lordship. We have filed one RTI.
Decision is of 21, whatever happens will happen. I am considering this matter as of 20.
Well, just for you intelligence. Well, fact, it is not disputed. Now, the question is how these people can also be accommodated. Because of that, the cabinet has taken a decision, my lord. So therefore, my lord, invoking the law laid down by Apex Code in RK SETI versus ONGC 1997 is if I'm seeking my lord to mold the relief here. Say on the ground that if the juniors were given promotion and there is no
This is not a promotion. This is not
direct recruitment.
These posts were not filled up in this manner.
Yes, yes, my lord. To that, to contain that, my lord, because the much prejudice is likely to cause, my lord. So therefore, my lord, the cabinet has also taken decision, my lord. My lord, I respectfully urge on two things.
Add a line that in future, after 2017, if there is any decision favoring them, this order will not go. But as of 17, you are not getting it, that post will have to be given to them. From that selection process, they will be.
Well,
We will have it day after.
yeah, my lord, we will come back with that. Grateful.
Think of it. Your post will be interfered with, put up for direct regular recruitment on that period of time. In future, if there is any decision by the cabinet to regularize contingency workers like you, ignoring that 20-year period, they are free to do it. This order will not happen.
That's fine. Well, that rota quota will also come. Let me see, come back with that.
On 6th. Development.
So, sorry, your counsel opposing you is here.
No, my lord, as per the information given by his colleague, my lord, the counsel for the other party is not available today, my lord. Letter of absence is also given. Other is also, my lord, on that day, matter was fixed when he was president.
He was present. Mr. Chaudhary has come down such a long way.
My lord.
Anyway, Mr. Chaudhary, we have heard it. You have given your written arguments also.
My-
Anything more to add?
Yes, my lord, if your lordship kindly gives me 10 minutes time, I'll. Back to the. I'll not take much time.
No, yes. Because I wanted to matter as the first item. Okay? Possibly it does not. Yes.
The prosecution case, your lordship knows, my lord, is that so far as my client is concerned, that it was involved in the conspiracy because of primarily three things. One is that transfer of rupees 5 lakhs. The other is the procurement of 3 mobile phones. And the third is 25,000 rupees, which has been deposited to the account of the wife of one of the accused persons who was involved in the murder.
To the mobile.
Yes. Now, on that,
The other two, this court was not very much convinced, but the third one,
yes,
we were
yes,
requiring you,
yes,
we were having a deliberation on the third.
Yes.
So the mobile subsequently was recovered from your company.
yes.
And there is even the statement of the husband. With regard to that aspect, there is nothing.
Exactly, my lord. I was harping on that because there was a query from the court that maybe the husband or the boyfriend, he took upon himself everything to protect me.
That is the second.
Yes,
With regard to buyback transaction, mobile, everything he has taken it on. I'm sorry, just to
yes,
understand.
yes,
But with regard to this 25,000.
yes.
He has not made a statement that I have transferred this.
My lord, for that, I'd like to draw your attention to one particular document
Please.
where it has been, that is,
86.
yes, your lordship is right, my lord. That is what I want to clarify. If your lordship comes to the statement of the Ronnie Lisi at page 107. What I'm trying to bring to your lordship notice is that it's not that he has made all these statements in my favor to protect me. He has also made some statements against me, but for which I would not have been arrested. Now, that is at the Lisi Ronnie statement at 107. I'd like to take your lordship to page 108. Because had he taken everything on him to protect me, he would not have made certain statements because of which I was arrested. Now, page 108, second paragraph. From the year 2007 to 19, for almost 3 years, I was trying to get divorce from my wife, Techi Meena, and file divorce petition in the court of district and session judge UPA, but she did not sign the divorce paper. I did not stay with her all these days. I just used to visit A sector house rarely to see my daughter, Yumiko. My father and my family members were supporting Meena. Meena is the wife of the deceased. And my father used to give her money for her expenses. We have 2-3 rounds of meeting with Techi family regarding me and Meena's relation. I wanted to get rid of wife Meena. When I was arrested in Delhi in 2019, it was Chumitaya only who was physically with me at Delhi. But I could not do anything to Meena, as in the last meeting with Techi family in April 2009, A sector, Naharlagan House, it was decided by both Lishi family and Techi family to stay together cordially as husband and wife. I was forced to agree to their terms to stay with her and not to do any physical harm to Meena. But I was not actually happy inside to stay with Meena as husband and wife. In that meeting, Meena's father physically assaulted me too, which I felt very insulting. So, despite the meeting, the decision, I continued to separately stay with Chumi at a rented house at Itanagar. My family members, especially my father, fully supporting Meena and pressurized me to come back. Meena used to be of very rude and stubborn nature. She used to keep boyfriend all the time. Recently, she was having one Naga boyfriend called Lafi. I do not know his full name, so I wanted to get rid of her permanently. But I cannot do anything directly to her, so I decided to change my behavior towards Meena by showing love and caring to her, win back confidence. I started visiting Meena, so and so, so and so. Now, if your lordship comes to the second paragraph here at page 109, later when I heard that
Top part,
Top
third
part.
line.
Meena marched so and so
Meanwhile.
during daytime and spent time with her and daughter Yumiko. Meena was happy for coming change in me towards her, but actually I was not changed. I was trying to win her trust. Meanwhile, I briefed Chumi to support me, winning Meena's heart, so she did not complain about my spending time with Meena.
Now, Mr. Chaudhary,
Yes,
we have seen the relation between these three people.
yes,
Girlfriend, wife, boy. Girlfriend is possessive, wife is possessive.
yes.
Now, what is the meaning of this sentence? Meanwhile, I briefed Chumi to support me winning Meena's heart so that she did not complain about spending my spending time with Meena.
Yes,
That
because
means
wife was
any-
complaining.
No. Any person, if that girl is so possessive about you, she will not permit you to go back with her. This shows that there is something more.
Yes, yes, true.
This line,
Yes, this line means that both of them are possessive naturally. Both
No.
of them.
both the girlfriend and the boy
Yes,
knew the action of the boyfriend was false and with a view to do some act, furtherance of something. Can you deny that with this sentence?
my lord, this sentence only.
Otherwise, this sentence will have no meaning.
I briefed Sumi to support me winning Mina's heart, so she did not complain about my spending time with Mina.
Meena,
Yes.
because why? If you are trying to win her heart, because you
Yes.
are trying to divorce her.
Yes,
You were trying to divorce her.
yes.
Now, if you want to win her heart, why would the girlfriend permit you? If there is nothing beyond that.
No, because she both the girlfriend and the wife, they want that the time should be spent with me.
I'm not on that, Mr. Chaudhary. I briefed Chumi to support me winning Meena's heart.
So that she does not complain staying with the girlfriend.
No, so that she did not complain about my spending time with Meena.
Yes.
It's the other way around. The boyfriend is asking the girl, saying the girlfriend, I took her into confidence so that she does not complain my going and meeting my wife. Now, why? She will complain naturally if there is and not another angle which she also knew. Because this brings in the knowledge part of the
Yes,
girlfriend.
I'll come to that a little later by completing the subsequent statements in the next paragraph. Later, when I heard that she was pregnant in the month of June 2020, I requested her many times about the child, but she did not listen to me. In the month of September 2020, when I failed to convince Meena to abort the child, I decided to do some final step to cause either miscarriage of Meena's child or by killing her by means of an accident or any physical assault to solve the problem once for all. The first part, because your lordship's query is answered in the first part.
Come down. Read further.
I was totally tired of the situation. Moreover, after hearing from Nape Bhabi, Lisis Sona's wife, that Meena is pregnant with a boy child, Chumi was upset and becoming very aggressive to me. Since previously on 2 occasions, Chumi had miscarriage of her pregnancy, so Chumi was also pressurizing me to choose between her and Meena. This is the statement. Had it been the intention of Lichironi to protect me, he would not have made this statement. Therefore, the court could not have taken two views, believe one part and doesn't believe one part. Otherwise, I would not have been arrested at all if these statements were not made. Now, so Sumi was also pressuring me to choose. So I somehow convinced Sumi to remain calm for some time and let me think of some final solution with Meena. I was also insecure as my final solution is that regarding the divorce. And that is what is indicated in the earlier statement, as your Lordship has pointed out. I was also insecure as my father already declared not to give any property to me, and if a boy child is born from Meena, then me and Sumi will be finished. In that situation, Meena will stay permanently, as my father would happily give all property to his grandson, Meena's son, which I do not want at any cost. I had a plan to eliminate Meena from our life. I needed a new unknown man to do it, so I contacted my old friend Kapwang Lati Luang to find a person capable of driving car to finish Meena by causing an accident and any other means. Now, this part is important. As per the plan, after a few days, Kapwang brought one driver, Dathang Suyang, alias so-and-so, one Tane Hoyang to Itanagar on 27/10/2020. I arranged their stay at Hotel Supincha, Itanagar. Kapwang had no money to come, so I sent 25,000 rupees to Kapwang in his wife's account through money transfer from Akashdip, Itanagar. So he says he has sent it because the prosecution wants to infer that it is me who has sent that amount. At Hotel Supincha, we finalized the plan to kill my wife Meena by an accident, so I kept Dathang Meena's house, telling her that she's her new driver. I used to take Dathang with me in my Creta car to make him familiar with the roads and places in Itanagar, Lahanlagan, Doimuk, so-and-so. So, whole plan was fixed at rupees 10 lakhs, 5 lakhs advance and 5 lakhs after the work is done. I gave advance, so-and-so, so-and-so. Now, one thing I was harping on the other day, that so far all these transfers of money is concerned, all the accounts of Lichironi were seized because of some cases in Delhi. So he was operating his business and everything through my account. Now, so far as because the question here boils down to that 50,000 rupees and 25,000 rupees. So far as 50,000 rupees transfer is concerned, I'd like to take your Lordship to one evidence that your Lordship will find at page 264. Page 264, it is a WhatsApp exchange of messages between the victim and her elder sister. And this has been certified under Section 65 of the Evidence Act. Now, your Lordship will kindly read page 264. Because the date of occurrence, your Lordship will remember 5th of November 2020. Now, here in the second notice, he was supposed to send me 1 lakh next week, ko dega bola hai, and said, baby ke liye rakho, January ke liye. So, shows that Ronnie has sent the money. Then your Lordship will again read, he was learning lesson, keep the money safely, don't waste. Then next page, ME, like how all blood tests required for pregnant lady. Then last line, Ronnie sent me, he is using her account. So it is clear from the documents records.
We missed out on last.
Yes, ma'am. That's why I wanted to point out. So everybody knows in the family that it is Ronnie who is operating all my accounts. So that explains that 25,000 and 50,000 is very clear here. So for
But where is that issue with regard to your wife?
yes, so far as mobile is concerned,
With regard to that 25,000?
so far as mobile is concerned, your Lordship knows the
There was a statement of,
conspiracy is said to be ascribed on me because of the buying of transfer of 3 mobiles. Vijay Biswas, alias Dengu, he purchased it. There is no documents to reveal that. Through his another employee, it was given to my servant lady. Then it was given to me, and I gave it to Ronnie. And these are the packets. We don't know what is the content there. Therefore, she didn't have anything to know about it. Now, if these mobiles are one of the factors to
No, I'm not on that. Where is that statement of that person of that Kisok?
Moken Riba.
Moken Riba.
Moken Riba 394. No, one sentence I want to add.
We are convinced with you of that mobile part.
No, mobile part, your lordship will, I have got another point to say. We are involved in that conspiracy. The allegation is both against me and Vijay Biswas. Both of us have been discharged by the trial court twice.
They are not PFP against Biswas.
They have not come against
Biswas.
Therefore, if the conspiracy was with regard to the mobile, the Biswas could also not have been exonerated. So these three mobiles do not play any role at all. The only thing that remains is that 25,000 rupees. And for that, as your lordship has pointed out, Moken River statement at 394, page 394. Now, your lordship will kindly note this is not a money transfer. The money has been deposited by cash.
From them, that person
Then the mobile number has to be given. Your lordship knows, my lord, how the OTPs come. For instance, my lord, my daughter, my lord, uses my credit card in Delhi.
OTP comes to
She says that when the OTP comes, you give it to me. I send her the OTP. So she performs. It's the same thing. Only thing they require is the mobile connected to perhaps some account. The cash was deposited. 25,555 was deposited, and the OTP was sent to my mobile in my name, and that OTP was given to the.
That is what I'm trying to find out.
Yes, that is
Where is that material?
No material.
Because this OTP, Mr. Chaudhary, there can be two circumstances.
Yes.
The main accused took the mobile along with him. 1. 2, he did not take the mobile along with him. Mobile was with you, your client. Then the OTP came, you gave the
That is
OTP.
one possibility. Yes.
One possibility.
Yes.
Third possibility is that it is you who had gone there and done the whole transaction. Now, negate the last possibility.
That I am not there. I said
To negate that, the learned court below had said there is no CCTV camera, so we will not accept that.
No, what the trial court says, because this is the only thing which came in the supplementary charge sheet. Because of the main charge sheet, they were all supplementary or only brought this 50,000 and 25,000 rupees transaction. Now, 25,000 rupees was admittedly sent to the wife of one of the accused persons for travel to Itanagar. That is what they say.
Because what we are finding is, other than the statement of that your accused, that gap
is filled up by that, which shows that it is always Lichi Roni who was operating the mobile phones. Who was operating my account.
Mobile phone came to be seized from your person.
Yes, but he was operating the account. That is the statement.
Where?
Otherwise, this statement of this gentleman, Moken Riba.
Mr. Chaudhary, for the transaction involving Moken Riba, no account is required.
No account is required. Only
It's
OTP.
only the mobile.
Yes, only mobile is required.
Only mobile is required.
Right.
It has got nothing to do with the account. The other transactions, we are satisfied that it is done by the bank in your account, but done by him. We are satisfied. No problem. Let's assume that. But here, where is that material to show that it was not done by you? That you had not gone there.
Now, my lord, I'll take it. I have to look it from the other side. Where is the material to show that I was involved?
That is trial.
That is not there.
That is trial. Because if you come to the impugned order, impugned order says that this factor will not give any credence because there was no CCTV camera. That cannot be the conclusion. We are only on that.
Your lordship, the trial court under 227 and 228, what are the things to be considered by the trial?
Prima facie.
Yes.
Prima facie.
Prima facie,
Great,
prima facie, the court has found that there is no material.
No, how did it, you come to this part, only
Yes.
on this part.
This statement of the Moken Riba.
Moken Riba, not Moken Riba, the conclusion of the learned court below.
Now, one thing your lordship will not lose sight of the fact that these are all recorded by the investigating agency. We cannot put 100% faith on those statements. Prima facie.
We cannot.
So prima facie, the trial court gave the finding that the materials are not sufficient. And as
You
your
come
lordship,
to page 440.
that is the order of the trial.
Trial court, the last three lines. With regard to the sending of rupees 25,000 to the wife of so-and-so, as noted, he denied and contended that it was the prime accused who had admittedly transferred the amount, the reason for which is exclusively known to him alone.
Yes.
Right? Then it again says, para 16, 1, 2, 3, 4th line, cursory perusal of so-and-so shows that Iowa has not collected any evidence to substantiate his claim that on so-and-so has transferred so-and-so. Now, para 17. Neither in the main charge sheet nor in the two supplementary charge sheets, IO has collected any CCTV footage from so-and-so or its periphery showing Chumitai depositing or entering inside the so-and-so. Prosecution has similarly relied on the hypothesis that any person transferring money from his or her bank account, this is a wrong thing, using register must be present in person at the time of transferring, which is vague and without clarity. This second line reasoning, not proper, because here no account was used. No bank account was involved.
Yes.
Now, what is there to show that you were not there? Or the mobile was always in the possession of? Some explanation has to be there somewhere.
My lord, if I read this sentence.
If it is not there, Mr.
Yes.
Chaudhary, correct me if I'm wrong. That would be a matter of pride.
My lord, may I read the paragraph 17, that sentence again? Neither the main charge sheet nor two supplementary charge sheets, the IO has collected any CCTV footage from the CSP point or its periphery showing Miss Chumitaya depositing or entering inside the Sage CSP Ganga on 25/10/2022. The prosecution has simply relied on the hypothesis that any person transferring money on his or her
Bank account.
person at the time of transferring the money, which is vague without clarity. Now,
No, please read it. The prosecution has simply relied on the hypothesis
yes,
that any person transferring money from his or her bank account using registered mobile must be present in person at the time of transferring money, which is vague and without, we'll not go into the thing. But what the trial court may have wanted to say is that the police was saying that the mobile is yours. Money was transacted at CSP Ganga. So natural corollary is that you were there.
yes, yes.
Right? Now, to dispel that, the learned trial court says that no CCTV footage, nothing.
Yes, that is what the trial court says. What I
Only
see,
we are only on para
yes,
17.
what I see is that the particular mobile was used in my presence. That was the case of the prosecution.
No, the case of the prosecution is that you used it.
Yes. So
You made the transfer.
True. Yes. So if I use the mobile to transfer and I was there, the Moken River statement would have.
Moken River says he does not say anything. He says, I am only concerned with the mobile.
No,
Mobile number given.
he's only concerned with the OTP.
OTP, mobile. Mobile, mean, just come back to that. Come back to that.
His statement is at
300 and yes, 394. You just come to that 394 answer down below. Read that.
Questionnaire. Do you remember who came to make the payment and whether it was a man or a woman?
Hmm.
Answer. As it has been long, I do not remember that. However, whoever came was carrying the phone number so and so as the OTP was shared right at this spot.
So the mobile was there.
Mobile.
Now the mobile was there. You were holding that mobile or the main accused was holding the mobile? It is silent.
Yes, that is a gray area. And
So
that
if
gives,
that is a gray area,
then there are two possibilities. Two views may be possible.
and the view taken by the prosecution, how can it be said to be bad?
The
In
view-
that view of the matter,
yes, the view-
prosecution view,
Yes.
you are trying to say about the learned trial court's view.
Right.
How can the prosecution view be said to be wrong? Because this is an area wherein everybody is silent. If you
Yeah.
come in there, if that transaction being unexplained all along, the other transactions have been explained. This transaction, because it goes to the wife of that man, you are roped in.
No, there are two aspects there. What are the gray areas I see? One gray area is that who was there is not known. Whether I am there or not, that is not known. And the trial judge wanted to say that if you wanted to prove that she was there, you ought to have had the
CCTV footage.
CCTV footage. That is one aspect. The other aspect is that money has been transferred for what? That has also not been explained
No,
anywhere.
no. So that shows that all other things, you have an explanation. Right, wrong, whatever is there, you have an explanation. You have an explanation for receipt of the mobiles. You have an explanation for sending the money 5 lakhs transaction because you don't know, you say it was done by him. But for this, there is nothing.
No, for there, the Ronnie statement is there. I
Ronnie
had
said
transferred.
you were running, but
No, Ronnie's statement, the trial court cannot take two views, accepting one part and not accepting other part. Because Ronnie also made
no,
statement
it's not
against me.
accepting, it's just evaluating.
Yes. Now on that.
You also said these are statements recorded by under 161 by the police.
Police, right.
How far we can give credence to those, that will depend.
Now on that, my lord, I'll come back to the limitation that has been imposed.
I know that.
On the revisionary.
I've gone through that. I know my limitations. But with this issue, because this is a very vital issue, because this is a payment made to initiate that offense, right? If that be so, prima facie, there seems to be a material against you.
Now, for that, my lord, I'd like to take your lordship to 397 once more,
Please.
and also to 227 and 228.
No, we are also aware of one thing, that this may be a very vague sort of a thing. And this, if established by the prosecution in the proceeding, through the statements of the witnesses who would be coming on record, under 319, you can again.
Exactly.
We are aware.
On
But
that,
we
my lord,
want to be clear on this. We know that. We can pass an order, we can cover our orders with that also. Passing a direction on that connection also. CRPC.
Now, your lordship, in the meantime, 4 witnesses have been examined. May I place the certified copy of those statements? Nothing.
Who are the witnesses?
These witnesses are the father and mother of the informant complainant. The first is the informant complainant.
Anything against you?
Nothing.
No need. Because those are not relevant also. Those people are not relevant. Maybe they have thought she is not there. Why should we bring?
No, in fact, the informant, there are 2 FIRs. The second FIR, he says, no, I did not sign any FIR. I do not know, because he made allegation against my client.
What do you want to show here, Mr. Chaudhary?
397. The first, your lordship may come to 227 and 228. Because this is the provision under which the trial court was examining the matter. I filed an application for discharge, and on that, these 2 orders discharging me were passed. 227 is discharge. If upon consideration of the record of the case and the documents submitted therewith, and after hearing the submission of the execution in this behalf, the judge considers that there is no sufficient ground for proceeding against the accused, he shall discharge the accused and record his reason for doing so. That he has done. Now 228, framing of charge. If after such consideration and hearing as aforesaid, the judge is of the opinion that there is ground for presuming that the accused has committed an offense which is not exclusively trial by the court of session, he may frame a charge against the accused and by order transfer the case for trial to the chief judicial magistrate or any other judicial magistrate of the first class and direct the accused to appear before the chief judicial magistrate, or as the case may be, the judicial magistrate of the first class on such date as he deems fit, and thereupon such magistrate shall try the offence in accordance with the procedure for the trial of warrant cases instituted under police. Is exclusively when it is exclusively tried by the court, he shall frame in writing charge against the accused. Where the judge frames any charge under clause B, subclause 1, the charge shall be read and explained to the accused, and the accused shall be asked whether he pleads guilty of the offence charged on the claim. Now, what had happened on filing of discharge? The entire the framing of charge was being considered, and charge has been framed against the 5 accused persons, and Vijay Biswas and my client have been discharged. Now that has been under 227, the trial judge has passed the order. Now this application has been filed under 397, 401 and 482. 397 I'd like to read because 401 is calling for the records, 482 is the inherent powers of the court. 397.
And legality or propriety of any finding,
Yes,
sentence or order recorded or passed as long as to the regularity of any proceeding of such, when calling for such, direct that the execution so and so powers of revision.
So your lordship is examining the correctness, legality or propriety of the finding.
Fine, we got it.
On that, my lord, there are various case laws of various high courts. I could not find any of the Honorable Supreme Court. One decision only, because these are all in the same line. I want to place one decision of the Delhi High Court. No, it's here. Delhi High Court judgment. Because of the causes. I'd like to read paragraph 9. That was a case regarding Domestic Violence Act as well as the maintenance application. Paragraph 9. The scope of interference in a revision petition is extremely narrow. It is well settled that Section 397 CRPC gives the High Court or the Session Court jurisdiction to consider the correctness, legality, or propriety of any finding, inter se, an order, and as to the regularity of the proceeding of any inferior court. It is also well settled that
It reiterates the powers under 397.
yes, because the last sentence, a court of revision considers the material only to satisfy its about the legality and propriety of the finding, sentence, or order, and refrains from substituting its own conclusion. Now, appreciation of evidence is also.
We are not here. We are only on 2 circumstances which come to our notice. One is that line in the statement of the main accused, that I had convinced her before proceeding to my wife, to convince my wife, with the earlier statement that he wanted to finish up. One, that statement which you took me through.
Yes.
Read with this 25,000 non-explanation. These are the 2 points which is.
My lord, I do not agree that it has not been explained. It has already been explained by Ronnie saying that I transferred all the money.
Fine. Then if I have to accept Mr. Ronnie's statement,
Yeah.
I'll also have to give a meaning. The trial court ought to have given a meaning to that part of the statement also, wherein he says, meanwhile, I briefed Shumi to support me winning Mina's hurt. So she did not complain about my spending time with Mina. And just before that, he was saying that these things I was doing only to finish around.
My lord, my submission would be, when there are two views possible, I have already given the case.
No,
laws.
Mr. Chaudhary. The view of the prosecution was to bring you in because of these circumstances. The trial court presumed that in absence of a CCTV footage, your presence cannot be.
Ascertained.
Now, whether that is correct.
My lord, the question is how far your lordship will scan the evidence?
We'll only examine whether that finding is correct or not. Because that much we have the power.
No, power your
No,
lordship
no, no,
has
I'm
the
not that.
power.
I'm not on that.
I'm not questioning the.
We will have to examine whether that finding of the court is correct or plausible. Only to that extent. If that we hold to be plausible, finished, then 390, no other way out.
Yes.
If we find that that factor which he said, that's not proper. That was something for the prosecution
To
to
decide.
establish in the trial, not here. Then we may have to hold that that order is bad, you will also be an accused.
Now, my lord, the question is, in any case, the charge has to be considered by
We
the
got it.
trial, by the trial.
I'm only opening up my mind so that I get something from you.
So on that, my lord, my submission is that when I have to be
So,
given.
yeah, we have detailed that.
Yes,
I've
I have to be given the benefit of doubt.
You have,
The
there are
prosecution could-
decisions of the Supreme
Yes,
Court.
but prosecution could not satisfactorily explain
No, but
the 25,000 rupees.
this written statement, written out submission deals with that. Yes, madam.
My lord, I'm reiterating, the state has not filed any revision petition.
I'll just clarify, your lordship, in my written statement, I've relied upon the statement of the prime accused, your lordship.
You have given a written argument.
Yes, your lordship. Tado.
I have one from Mr. Thama.
The state, without preparing a revision petition, submitting written statement is something, written submission is something.
Okay, ma'am.
Yes, your lordship.
I think we have already asked Mr. Chaudhary about this.
Yes, I'll just clarify to that effect to your lordship, because my main contention with regard was the statement of the prime accused, your lordship, with all the connection of Jumitaya conspiracy involving in this crime, your lordship. Now, as I have already also given in my written submission that the crux of the case, the first initial conspiracy started when he permanently wanted to get rid of his wife, your lordship. Subsequently, the next action was that to please her, to convince her to be with her.
That statement.
That statement, your lordship. He briefed her. Subsequently, what has happened? It did not go according to the plan. There is a clear statement by the prime accused that you be with Meena, but don't have any physical intimacy, your lordship. Subsequently, beyond the plan, she gets pregnant.
June.
That's when the plan escalates. It ought to have been delayed, but due to pregnancy, it escalates, and that's when this happens, your lordship. Also, with regard to your lordship, will see the mobile phone, your lordship. As per the submission made by senior counsel, your lordship, states that she does not have any idea with regard to the mobile phone, the 3 mobile phone that was used in the crime, your lordship. If I may take your lordship to page number 121 again, your lordship, of Jumitaya. The statement, the submission that it was a package. She did not have any idea if there was mobile or not. The second paragraph, your lordship will see the third line, the second line. So he asked me to receive some mobile phone SIMs from Vijay Vishwas. She was aware of the SIM phone and the mobile phone.
This is too stretching it too far.
Yes,
This we are not convinced.
Yes, your lordship. The rest,
That statement and that one, that would require an examination.
also your lordship will see that with regard to the CCTV in the CSP sport, your lordship.
That's the only thing we are worried about.
Yes, if I may just clarify, your lordship. if the CSP point was till this date in existence, Your Lordship, the IO would have obviously taken the CCTV for evidence, Your Lordship. The CSP at present is not present. What the IO did was, he contacted the branch from where the ID was, transaction was taken. They contacted, therefore, Your Lordship will see the statement, the reply of the manager, Your Lordship, that our, yes, it is at page 370, Your Lordship. Your Lordship will see the reply was written by the Bankit Service Private, person named Vinod Pudir, head operation, Your Lordship. He has given the information that this account was of,
Mokan Riba.
yes. If it, the CSP was, there is no, therefore my submission is that the CCTV that was stressed while discharging, Your Lordship. That's not the point where, that's not the only point, and it's a very vague point where he could have discharged, Your Lordship. And therefore, their presence, as to who was present, there is no, this is an admitted fact, there is no dispute that Chumi's mobile was used for receiving of OTP, Your Lordship.
There were 5 OTPs because there were 5 transactions.
Yes. 25 per transaction. 5. Yes, 1 rupee was.
No, my lord, just one minute, my lord, I just want to just or the later complete. I just want to say one sentence.
Now,
Yes.
now in regard to the law point, Your Lordship is well aware that conspiracy, as I has already stated in my submission, Your Lordship, it normally happens in secrecy, Your Lordship. There is no proof evidence as such, Your Lordship. And therefore, circumstances evidence has to be taken, Your Lordship. Now, the trial court during the framing of charge has to keep in mind that charges like criminal conspiracy, the charges should be so strong to make a presumption that that has happened, Your Lordship.
Yes, Mr. Chaudhary.
Only one point after my learned friend was submitting, we had talked about several possibilities regarding transaction of 25 thoroughly. One possibility I did not submit before Your Lordship. In all those consumer sales points and the banks, the keeping mobile, a CCTV is mandatory. One possibility is that CCTV footage was there that was not produced by the prosecution because she was not there in the CCTV. And that question has also not been recorded whether you have got a CCTV or not. Otherwise, this would not have come to the mind of the trial judge.
This is a transaction of 2000.
2002. 2020. 2020.
Before COVID, these were not that.
No, consumer sale points because large transactions are taking place.
These are small points, shops in the. You go down.
No, they have to
You
take a
go down,
license.
Before after they cross the Burum Bridge.
Yes.
On the left hand side, you will find one. State Bank of India. And whether there is
this possibility has come
CCTV.
to my mind
Fine,
because
it's
my lord, there is not a question even that do you have a CCTV facility? No, it was not there.
You are
That
trying
had
to
been
say
said.
that the police was convinced that she was a party to the whole transaction, but they had no material against us.
Your Lordship, that CCTV, Your Lordship, that as I have explained, Your Lordship, if there was a CCTV or any proof, Your Lordship, it could have been taken and evidence would have been proved, Your
He
Lordship.
says,
My-
it's taken.
No,
Maybe.
there is a maybe. My contention is there was no evidence, the shop was closed. Now, therefore, this letter was sent to the branch manager
The
asking,
shop was
is
not in existence.
not in existence. Therefore, Your Lordship will see even the statement of Moken Riba, he says that he was prior to his present job, he was serving, he had this CSP, Your Lordship. If I may take Your Lordship to Moken Riba's statement. Moken Riba's statement, क्या बेटा? 395, Your Lordship. 394, Your Lordship. If I may read, Your Lordship.
Okay, done.
Yes.
I have recently closed.
Yes. The other ground that was on the last occasion, it was never taken into consideration was the WhatsApp message, Your Lordship, that has been shown now. If I may clarify, Your Lordship, this evidence was submitted by the elder sister of the late deceased, Your Lordship.
Right, under the evidence.
Yes.
Section 63. It's an evidence.
Yes.
Yes, what do you want to show from there?
Page number 263 that was relied upon, Your Lordship, today. The effective paragraph page is at page number 264. This was the conversation between the victim and the accused, victim and the elder sister, Your Lordship.
That's a fact. He was
That's-
paying her money.
Yes.
Husband.
However, the same contradiction by Chumi's her own statement under 161, Your Lordship, that she has, out of love, has transferred it. It was her account. The fact that her account was used, her mobile was used.
That was further clarified in a second statement. That was further clarified in the second statement. Where is that second statement, Mr.?
At page number 119, Your Lordship.
As per advice of
Roni.
Ronnie.
The fact remains, Your Lordship. In the entire crime, Your Lordship, her mobile phone was used, her account number was used, Your Lordship, her check was used, Your Lordship. And even after all these evidences, Your Lordship,
The contradiction, if you want anything,
yes,
is at page 120 and 121.
the question that was put up, Your Lordship, as per the advice of Roni.
She denied knowing Kapong, the maid.
Yes, yes,
But on re-examination, anyway, these are statements recorded by you.
yes, Your Lordship.
What value? But thing is, then she gives an explanation during the re-examination saying that, no, I know her, I know him
Yes, Your Lordship.
from
Even-
my daily days.
Even with regard to the 3 mobiles, she denies.
The number is, Kapong's number is there in a,
She knows him since 2017, Your Lordship. Blatantly, she denies the IO. She did not cooperate at that point of time. Even with regard to the 3 mobile phones, Your Lordship. She then gives her explanation that only she did not disclose about the mobile phone because she was scared. That, Your Lordship. Therefore, my humble submission is that Your Lordship will see in the entire crime, Your Lordship. Her SIM card was used, her mobile was used, her account was used, her check was used. Above all, she seems to be a joint account, but then she gives the credit to the prime
That-
accused of
that-
having any.
other than,
It's not a joint account. It's not a joint account.
It's her own account. That is a possibility.
Yes, sir.
That is a possibility, and the tribal learned court has come to that conclusion. That it was the main accused who was using that amount. We agree. We can't. The only thing which we had was that line and the CSP. And we consider what the senior counsel has said. And if we come to a conclusion that this is fine, then we will make an observation that 319 is always open to you. And rather we come to a conclusion, no, that is not correct. Then we may say that she will also be included as an accused.
Yes, sir.
We'll examine research. These are the two possibilities that. Anything?
No.
We can close the matter? Yes. Mr. M.K. Chaudhary, Senior Counsel for the petitioner. I heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. T. Srinivasan, Learned Counsel, appearing for the petitioner. Also heard Mr.
This is the Mr. Kar.
Oh, Mr. Kato, assisted by Mr. M. Kato. We'll put both the names.
My lordship.
And so, Learned Counsel for that. There be a weightage, more weightage. Learned Counsel for the petitioners. Also heard Mr. J. Sering.
J.
Sering, Learned Counsel appearing for the
Petitioner, Your Lordship.
petitioner. उसको आगे में दे दीजिएगा. Then this. And Ms. MST Jimmy, an additional public prosecutor appearing for the state respondents. The parties have also brought on record their filed their respective written arguments. Hearing concluded, judgment result.
Obliged. Well, there is only one mistake in the
Please.
written argument. The written submission. One date and one page number was not given. Where is the revision? Only one small mistake. I'm sorry, madam. The citations given, one is written 2020 first case, that will be 2010.
2010 9 SSC.
Yes. And the paragraph number of one citation was not given.
2000 SC 2665. SB Johari.
And the one, we have not given the paragraph number, that will be paragraph 17, 17.1 and 18.
I think we have gone through that.
Yes, your lordship is already gone through.
Thank you.
Highly obliged for giving.
Thank
this.
you. I should be thankful to you all for having explored this subject. What her name? ये CAD हो गया? नहीं आप CAD.
Item number 5.
We have interfered with that order, but that order interference being on account of that procedural lapse, we have provided that if there is any such public nuisance or thing which prevents the construction of the work, the authorities at liberty, in spite of our disorder, to proceed in the matter in accordance with law by following the procedures.
Yes.
You will have the orders.
Yes.
Some corrections are there.
The-
Number 6.
Mr. Counsel, we could not dictate it the full half dictation, none. I'll pass the orders. We are dismissing your writ petition, holding that the process is in tune with the NIT, right? You'll have the orders tomorrow, today, or latest by tomorrow.
Deeply, my lord.
Item number 7.
My pleasure. My lord, this is the regarding web silence, the Kabang decision dated 15/11/2023. My lord, here, there is a, my lord, a system, village level Kabang, Bango Kabang and Bogum Bakang Kabang, as per honors for the Civil Court Act, my lord. Now, here,
Now, what has happened to this execution order?
this execution has
Taken place?
yes, execution has taken place.
We'll issue a notice then.
Yes, my lord.
We'll issue a notice.
Yes, my lord.
Because this is an execution order of July.
July.
Today, what, we'll issue a notice, ma'am. What do you say?
Lordship, the agent aggrieved party from the upper one Kebang decision, they never appealed. After the execution only, which was taken place in,
July.
no, 2022, the original order, Kebang order.
I know, execution took place in July 23.
Yes,
Yes.
So today they are before us in March 2024. So no
yes,
interim directions, we will issue a notice, we'll examine.
yes, Lordship.
Heard Mr. So-and-so, Madam Kami naam le lijiyega.
Either.
So-and-so. Issue notice, returnable 4 weeks. Ms. So-and-so. Your senior, your
Additional senior
additional senior government advocate. Enters appear, accepts notice on behalf of respondent number 1, 2, and 3. No formal notice be issued.
Not 3, Lordship, not
2.
3 is,
3,
3 is private respondent.
no, 3 is the additional deputy commissioner. 4 is private respondent.
Oh, Lordship, yes.
However, extra copies of the so-and-so be furnished to MS so-and-so, learned senior. Petitioner to take steps for service of notice upon respondent number 4 by way of registered post with AD. So, list this matter again after 4 weeks.
Obliged.
Item number 8.
My lord, this item number 8, my lord, although it was listed after 2 weeks, but yes,
No, it was fixed on 11th.
11, but we make a mention just to, my lord, demonstrate certain facts, my lord, that how they have considered the fact. They have categorically said, my lord, NAT was never plotted. In fact, my lord,
That's
yes,
why we passed
yes,
it
my
on.
lord, I have the document.
Where is the council?
Council, my lord, I don't know. My lord, this is the 2-paper publication, my lord, I made an extra copy for your lordship convenience. My lord, first is the letter written by the executive engineer, my lord, to the superintendent engineer, my lord, who is the tendering authority. My lord, explaining, my lord, why e-tender cannot be done. My lord. The second one is the approval, my lord. The third one is the requisition sent to the IPA department for publication. And rest are the, my lord, 2 papers, my lord, local 2 papers, my lord. If the lordship see it, my lord, down below, my lord. Then the constitution of board.
Mr. Namam, why
My
don't
lord.
you do one thing?
My lord, I,
Just file this by way of an affidavit.
my lord, I'll do that, my lord. I just asking for slight modification of the interim order. I'm not asking for, my lord, vacating the interim order, my lord.
I got it. You
My
wanted
lord.
that the process should continue
Yes,
till that time.
let it be subject to the outcome of the repetition, my lord.
No.
Not, my lord.
Without him, I think it's not possible.
My lord, of course, I informed Mr. Bui, my lord.
Maybe he has some, because we fixed it on 11/3. We will have it on 11/3. We'll vacate this order, don't
My
worry.
lord.
You just bring this on
Yes,
record
yes,
by
my
way of a small affidavit.
If it is, yes, I'll do that.
Just clarify
My lord, I'll do that.
that although the contention is that no such thing was done, however, paper publication, and also give me the number of bidders who had appeared.
My lord, yes.
Huh?
Yes, my lord.
This matter has been listed today at on the behalf of Mr. Anaj Nawam, learned additional government advocate general, who has contended that the instructions has been received by him, and therein it is, and therefrom it is seen that the authorities had made wide publicity to the tender notices before proceeding with the consideration of the bids so received. Full stop. Mr. Nabam submits that contrary to what was held by the petition, what was contended by the petitioner, that even the advertisements were not published in newspapers. Mr. Nabam has placed before this court the newspapers wherein the advertisements as advertisement for the work as involved in the present proceedings were so advertised. Full stop. None has appeared for the petitioner. Full stop. Next. In view of the above position, Mr. Nabam shall file an affidavit, short affidavit, bringing on record the above points also, and also apprise this court in the said affidavit as to the number of bidders who had submitted their bids in pursuance to the advertisements, bids so advertised. So list this matter again on 11/3/2022. If required, we will modify this.
Only problem, my lord, is that accepted the bid submitted by the private response, my lord. Now, letter of acceptance has been issued, my lord. That is the only problem. Letter of acceptance, my lord.
Keep it at that.
For
Keep
the
it at that. Keep it at that. I've said not to award. Keep it at that.
My lord.
11 we will. If you give me this, 11 we will finish it.
My lord.
I don't want to do it in his absence.
Correct.
So if you file an affidavit and he is not here, this court can proceed in the matter.
Absolutely. Oblige.
Yes.
Lord, item 9, I appear for the petitioners on
Yes.
behalf of Mr. Glenn. Lord, the issue in this is we have challenged a circular issued by the CBIC and a consequent show cause notice that has been issued, and minutes of the GST Council. The identical matter had come up before the principal bench in Guwahati, and their lordships were pleased to issue a detailed order and also an interim direction staying the proceedings. If my lord may kindly have page 432, where we have annexed that order, and the facts are identical, the issue is also identical. Page 430, my lord. It's an order dated 2nd of February 24 at page 431. May I be permitted to read out that order, my lord? In fact, I was appearing in that matter as well. Heard Mr. So-and-so, assisted by so-and-so, etc., etc., my lord. Para 2. The present writ petition under Article 226 of the Constitution of India is preferred to assail a demand cum show cause notice dated so-and-so, issued by respondent number 4 to the petitioner, asking the petitioner inter alia to show cause as to why an amount of rupees so-and-so towards CGST and SGST in equal proportion should not be demanded and recovered from the petitioners under section so-and-so of the CGST Act and corresponding provisions of the SGST Act and the IGST
We have
Act.
got it, Mr. Ghosh. You
Yes,
do not
my lord.
trouble yourself. We
Yes,
have
my
got
lord. So, and then, my lord,
it. Yes,
after
Mr. Karov. What do you say?
My lord, at this stage, my lord, notice may be issued. I will.
But there is a notice hanging over his head.
My lord.
There is a demand notice. So we'll follow the orders passed by the coordinate bench. There is a detailed order here. We'll follow that. Page 440-35.
My lord, in that case, my lord, may I pray that, my lord, I may be allowed some more time to take instruction from the, my lord, department. Subject to
Let him
consider.
have his instructions. We'll protect you.
no difficulty, my lord.
You don't want me to issue a notice today. Or you want me to issue a notice?
My lord, at this stage, without interfering, my lord,
No, I'll have to stay this. This is already under stay. How can there be not fair?
then in that case, notice may be issued.
Notice. We'll issue a notice, Mr.
And protect us, my lord.
Yeah. Heard Mr. S. Ghosh, learned senior counsel, assisted by
Assisted by Mr. Glenn, my lord.
G. Tado. Assisted by Mr. G. Tado, learned counsel for the petitioner. Also heard Mr. M. Kato,
My lord.
learned deputy SGI, appearing for the respondents number
1, 3, 4, 5, and 6, my lord.
1, 3, 4, 5, and 6. So who is left out? 2.
So the state,
And heard Miss MS so-and-so, learned counsel, appearing for the respondent number Two. Full stop. Mr. S. Khush, Learned Senior Counsel. Full stop. The present proceedings has been so instituted, presenting a challenge to show cause notice dated 29, it's 29/9/2023, same,
Yes, sir.
29/9/2023. A demand come show cause notice issued by the respondent number 4, requiring, what is the amount involved, Mr. Ghosh?
21.26 crore approximately.
Just give it in writing. Amount.
Page
So
125. A lot will find it at
Page
page
1,
125. Para 16 small a.
demanding an amount of rupees 21,26,25,000. पूरा लिख दीजिएगा. Rupees 21 crores, 26 lakhs, 25,000 towards CGST and GST in equal proposition should not be demanded and recovered from the petitioner under section 74(1) of the CGST Act 2017 and corresponding provision of SGST Act 2017 and IGST Act 2017 along with interest, etc. for evasion of GST pertaining to period July 2017 to March 2021. Mr. Ghosh has placed reliance on an order dated 22/2/2024 passed by a coordinate bench of this court in WPC number 488/2024. We have perused the same and having noted that the issue as involved in the said proceedings and the issue involved in the present proceeding is the same. We accordingly hold that the petitioner in the present case has made out a prima facie case for relief, for grant of interim relief. Accordingly, the next line, accordingly, it is provided that till the returnable date, till the next returnable date, the impugned demand come show cause notice dated 29/9/2023 shall remain stayed.
Blessed. Extremely blessed.
List this matters after 6 weeks. Issue notice there, returnable 6 weeks. After 6 weeks.
Blessed.
Item number 10.
May I please, your lordship?
Yes, Mr. Das.
Lordship, I am challenging the impugned order of the DC regarding the certificate proceeding, even when we had sought for a installment under Rule 80.
Yes. Who is appearing for the bank?
Yes, madam.
You are appearing.
Yes.
Take money.
Well, the 2008 matter.
We'll ensure he continues paying you. Otherwise, he'll be. What benefit? You fight. No money is coming to you. This is public money. Give him. How much will you pay him today?
Today, lordship, I have no instruction.
Tomorrow?
I have to take the instruction
You
again.
said you are ready to pay.
The way installment was 20 lakhs, that part
And
was
20 lakhs is out of what amount? 6 crores.
no 3 crores. That is the 3 crores.
2 crores. Pay. We'll stay. 2 crores. 1.5 crores.
Lordship, we not
Take
have
the
that much of, if that much
Take
amount
the
of money.
instructions. Take instructions. You have taken money from him.
3 crores was the first.
You have taken money from him.
Lordship,
How much have you repaid?
Lordship, the what
Nothing is there. You have not brought on record any statement showing that these are the amounts we have repaid.
Lordship, the initial
The money
amount.
is not your hereditary property.
No, Lordship.
This is public property.
The sanction amount was
1.5 you pay. We'll see for the rest. When do you want the matter? 1.5.
Lordship, I have to take the instruction. I cannot say.
Come back. 2 o'clock.
Okay, Lordship, I'll come back.
1.5 you pay immediately. Within a week, we will stay. Right? And the next 1.5, you discuss with the bank how they have proceeding, do it.
Lordship,
We are taking it on ourselves.
Comfortable
law.
would have been 20 lakhs per month EMI, which we had sought for. That would have
Sorry.
been, that would have been
Sorry,
comfortable.
when was the loan sanctioned to you?
Loan was 2006,
6. Today is
23.
2 crores, not below that.
Plus.
Otherwise, we are dismissing your petition. Go to the appropriate form. We are dismissing your petition. 2 crores, 2006 onwards, public money. This is not the way you do it. Okay, you have come so long, 1.5 to start it.
Okay, I'll take my instruction at 2
Have it.
o'clock. At 2 o'clock?
2.
Oh, yes, sir.
Be here too.
Yes.
2 बजे बुला दो. ठीक है ना? 2 बजे. Oh, जाना है ना? दीजिए. You are going back. So we'll have it when?
Week's time may be given. I'll be here.
11th?
12th.
12. On the prayer of Mr. Ardas, list this matter again on 12/3/2024. Mr. Ardas shall place before this court the reply to the query as raised in the matter. Full stop. On the matter. Full stop. We are not recording it. It is already recorded in the. We can rewind it. Show your client that. I'm not putting it in down my order, but it's already recorded.
Till then, Lordship.
Nothing.
At least till till then, Lordship.
You are arrested, you will be in civil prison.
But
You're
still,
not in a criminal prison. They'll be having a headache keeping you in civil prison.
Yeah.
They'll have to spend money.
no, we have to give the money. Then only that's the.
No, I think initially, they'll have to spend.
No, we have.
Right, Mr. Dotto?
No, we have to pay.
The creditor has to pay.
Then they will.
They will give when they want
Yes,
to give. But initially, they'll have to give.
I'll
You
issue
give a
my
big list of your likings. You know what is to be given. But these things, at least this court will know. 1.5 to start off with, right?
Yes, yes.
1.5 to start off with, and then we will say how to proceed.
Yes, obliged.
Understood. Yes, Mr. Sakya, why are you here? You are here today. You are here. Okay, but yes, Mr.
My lord, this is a matter, the petitioner is a manufacturer of cereal-based ready-to-eat food products. Now, there have been requirements from the state for supplying it to various ICDS and child development projects. And they have been doing it from the year 2016-17. Your Lordship will kindly find the completion certificate that the government has issued
Okay,
to us.
but what is the criteria that has been changed now?
Now, page 49, your Lordship will find, particularly clause 5 and clause 8. Page 49.
49.
49. Clause 5, they say that it will be assessed on a basis of 25
I don't
points.
think so. This is done by the state. This is done by the central government.
No, but the tender is by the.
Fine, but the conditions in this is set by the central government.
Yes, that may be the case. Now, the question is, now they say that there is a vague, aspect in this matter, in the sense that, your Lordship will kindly
The
see.
central government is not a party here.
No, but then unless and until they make a stand.
No. These things, as far as ICDS thing, all these things are settled by the central government.
No, the tender is by the
Okay,
state.
what is the supply of so and so?
Tender is by the state.
No, okay. Tenders were by the state.
Yes.
There was a move also sometime in between to even stop these things. But again, they have started. Okay.
Yes.
Supply of micro and energy dense put to
There's social welfare, women and child development department under the ICDS scheme for last 3 years. Now they say that if I have served in for last 3 financial years, now it is not clear from it that how these points will be generated. If I serve in 1 state, then 5 points, 2 state, 10, 3 states 15, and 4 and above 25. Now, will it be a requirement of each financial year wise, or it will be a composite 3 financial year wise? That is not spelled out. This is number 1. So there is a room of ambiguity here, my lord, where there can be manipulations. And the second one is the clause 8. Clause 8 says that net worth of the bidder during the last financial year 2023, as per audited balance sheet supported by CA certificate, up to 20 crores, 5 points. Now here the project cost is 10 crores. And I qualify for the project cost because I am also one of the suppliers now.
You can apply? There is no bar in applying
I
this?
can apply, but I'll be ousted.
Who?
Even if I apply, my lord, because down below your lordship will see minimum points I am required to score is 90. Now, if this criteria is applied, particularly clause 8.
When is the last date?
14th of March.
14th of March. But Mr. B. Dr. Leonard.
Yes.
As Dr. Leonard Senior Counsel, assisted by Miss
IDAS.
IDAS, Leonard Counsel. See, coming from there, I forget everything. Now I am here, Arunachal. IDAS, Leonard Counsel for the petitioner. Also heard Mr. Navam, Leonard Additional Advocate General, appearing for the state respondents. Issue notice, returnable 3 weeks. Who will take notice, Mr. Navam here?
I for 1 and 2, my lord.
Who will
Well, they are the only 2 respondent states. Others are pro forma, my lord.
P. Pango, my lord.
P. Pango, Leonard Counsel, Government Advocate shall receive notice on behalf of respondent number 1 and 2. Full stop. Extra copies, so and so. Pro forma we are not issuing now.
Yes.
2 weeks. 2 weeks. Mr. R.S. Nawam shall on the next day place before this court the instructions as to how the marks as allotted at serial number 5 for the supply experience is to be awarded, as well as to the basis on which the
Clause 8.
Clause 8, as to how the specification of requirement of 20 crores for being granted 5 points, and the other specification made therein was so made when the work in question, according to Mr. S. Datta, Learned Senior Counsel, is for a value of 10 crores.
10 crores.
10 crores. Full stop. The petitioner is required to participate, submit his tenders in the said bidding process. The respondents shall, on receipt of such tender, consider it on its merits. However, the same will not be finalized without the leave of the court. The bids as received in pursuance to the tender shall be processed and finalized. However, no work order shall be issued without leave of.
No, my lord, there is one point, my lord. If they follow this clause 8, my lord, I'll be ousted in the
I said
technical.
on merit, they will do what they want to do. They will give the clarification, but they will not issue a work order without leave of this court.
Yes.
So if you are in, we bring you in, you will get
But
it.
otherwise also, I may just draw your lordship's attention to one aspect of the matter. The present term is continuing in pursuance of a tender floated in the year 2021. And the condition was that
It will continue till that new person.
till the new
And
person
you
comes.
are supplying.
I am
So now
supplying.
you will continue.
So,
We have facilitated that for
my
you.
lord, page
We have already facilitated.
I
that
just
for you.
draw your lordship's attention to page 25, my lord. My submission will get clarified from that. Page 25. Governor of Arunachal Pradesh is pleased to extend the contract period in respect of the following manufacturers. Distribution of ready-to-eat products, food items for two Anganwadi centers of supplementary nutrition program during the year 23-24 till finalization of the next tender process. So even if, my lord, the stay order is operating, my lord, nobody's interest is going to be disturbed.
That's good.
Yes.
We have said no leave, but you continue.
Without any leave, my lord, there should not.
Continue. And if they justify on the same day, we'll ask you go.
My lord, in that case, since it is coming after 3 weeks, my lord, can I?
2 weeks. 2
My
weeks.
lordship said 2
Date.
weeks.
Date. आज कितना तारीख है?
2 days for my lord.
On 18th,
18th.
We will have it on
18th.
No, 19th, will it be impossible?
19 Miller hearing days.
20?
Okay,
Because 20, on 23, 2020.
23.
So now you have your instructions
My lord.
and let them
But when,
process.
yes, ma'am, but when we see. my
And you
lord-
are also at a benefit because you are getting it at the old rate,
My lord,
2001 rate.
if you compare the rates, my lord, yes, my lord. There is.
They are getting it in
The children is also not hampered. So we'll see after 2 weeks if if there is some material, we'll ask him to go.
Well, can I get this a copy of the order, my lord?
Copy of the order to Madam Kudichi. Correct on this.
deeply obligable.
Like one.
May I please?
Yes, Mr.
My lord, without public interest, my lord, without any administrative exigencies, my lord, this transfer order, the impugned transfer order has been issued. My lord, the petitioner is, my lord, even not able
Where
to.
is that order?
My lord, page number 37, annexure 4. Single, my lord, transfer. Page number 37, my lord. Sri, so junior engineer is here by transfer from the office of the executive engineer.
How long have you been here?
My lord, admittedly, since 2015.
Then
No, my lord, my at this stage, my lord, admittedly, my lord, and
nobody has been brought in your place.
yes, my lord. My lord, we are not getting any information. However, my lord, this is a purely a political transfer, my lord. I am engaged as the, my lord, the presiding officer. I have gone, my lord, the training for
That somebody else can step in. There is no
yes,
problem.
my lord. This
Have
is,
you got your complete instructions? Mr. Kato, complete instructions are, we have got in this case.
Yes,
complete in all respects.
my lord.
Huh?
Yes,
We'll have to close it. If you have not got, we would have given you a date.
my lord. My lord, even my mother is, my lord, also, my lord, is a heart patient, my lord. And my lord, recently,
We'll ask this order is within that circle itself. Transfer is within the circle.
no, my lord, one end to another end, my lord.
But
It is
in the circle itself.
no, my lord.
Then
It is in
How
the
can the superintending engineer transfer you then?
my lord. He is the only appointing authority and transferring authority.
Okay, that means he is being transferred within that circle.
No, my lord. It is in Anjor the Anjor
Same
district.
district.
No, my lord. It is transfer is at Tawang, my lord. One end to another end, my lord.
But
the
if both the posts are under the superintending engineer,
Superintendent, no, my lord.
then how is he transferring you?
My lord, he is the only, my lord, the sitting, my lord, the head of the department of the, my lord, sitting at
I know
the
that.
head
He
office.
can't transfer you to an area outside his jurisdiction.
My lord, he can.
No, how can he?
It's because, my lord, he is the appointing authority and
I
he
know
is the,
that. If he is transferring you to a jurisdiction under a different, yes, how can this be?
This is superintending engineer coordinator.
Where is he? He is in the,
He's in Itanagar.
okay, he is the one who
Who
is not the
transferred-
superintending engineer of that circle.
my lord.
Okay, okay.
Coordination.
Yes,
Yes, the power.
So therefore, my lord, at this stage, my lord, since I'm also, my lord, got injured, even, my lord, I'm not in a properly, my lord, is
you have already been relieved, no?
no, my lord. At this stage, my lord, even I made a representations to the authorities for consideration, my lord, that has not been taken into, my lord, consideration. At this stage, my lord, the otherwise also, if lordship interferes, the impugned order, my lord, nobody is going to be prejudiced, my lord. Since I am there, my lord, and I am.
They may have some reason. Yes, Mr. Ratan.
Legally, he doesn't have any enforceable right. However, there is an representation.
We'll ask for that to be
Yes,
disposed of. Till that time, don't disturb it. But Mr. M. Kato, learned counsel for the petitioner, and also Mr. N. Ratan, learned counsel, additional AG, appearing for the state respondents. Also, the present proceedings petition has been instituted by the petitioner, being aggrieved by an order dated 23/2/2024, issued towards transferring from the office of the executive engineer, Haulian Division PWD AP, Haulian, and to the office of the executive engineer Lumla Division PWD AP Lumla. Also, it is the contention of the petitioner that the said order of transfer has been so done without there existing any administrative exigency and or public interest involved in issuance of such order of transfer. Mr. Kato, by drawing the attention of this court to pay the order dated 23/2/2024 has submitted that the said order also does not reflect that the same was passed in view of any public interest
Right.
involved and or administrative exigencies. So, the petitioner has submitted a representation before the authority issuing the order dated 23/2/2024 on 1/3/2024, and the same is said to be pending in the so, without entering into the merits of the matter. The superintending engineer coordination PWD Arunachal Pradesh Itanagar and or any other authority competent to order transfer of the petitioner transfers in the transfers like the one involved in the order dated 23/2/2024 is hereby directed to take on record the said representation dated 1/3/2024 and to dispose of the same by way of a speaking order. Full stop. The said representation be disposed of by the superintending engineer coordination bracket number PWD and or any other authority competent in the matter within a period of 1 month from the date of receipt of a certified copy of this order. Full stop. The petitioner thereafter be communicated with the outcome of such consideration in the form of a speaking order. Full stop. Subpara. The above, full stop. The petitioner shall, to facilitate the exercise as required to be carried out by the order of this court, shall submit a certified copy of this order before the superintending engineer coordination.
My lord, along with this writ petition.
Arunachal Pradesh, huh?
Along with this writ petition.
No, writ petition is for me, not for them.
My lord, for consideration, my
Writ
lord.
petition is mine, not for them.
My lord.
Then you should have to gone there, not.
My lord. My lord, since it is not well drafted, my lord, the
Okay.
representation, my lord.
The petitioner is also permitted to file an additional representation bringing on record further contentions as may be called for, along with, and he would submit, he would submit the same along with a certified copy of this order before the superintending engineer coordination PWD within a period of 7 days from today. Full stop. Till the issuance of the speaking order as required herein above after completion of the exercise so required, the order dated 23/2/2024 shall not be given effect to by the respondent. The writ petition stands disposed of. With the above observations and directions, writ petition stands disposed of. Yes, Mr. Pani.
My lord, you will recall, this is the matter, my lord, where the selection process has been put on hold because the,
Yes, we had required them to
yes,
bring on record the order dated.
30/11, my lord, I have furnished a copy, man.
No, it's here, 30/11. This 30/11.
Yes.
Yes, who is appearing? Mr. Singh was here.
Yes.
Yes.
I would just like to apprise till he comes, my lord. I talked to him, he said he has brought the instruction. Only 10% appeared. Charge sheet was filed way back on 17/3/2022.
We
2 years.
intend that
Yes.
what were the steps they have taken.
Yes.
Let's see. You wait, let him come.
Yes.
We'll
Because
do it.
10%, my lord. I say I'm a football player. These are the certificate, they are genuine or not. That has to be seen. That is all.
Yes, Mr. Singh, what do you have?
My lord, on the basis of the direction of my lord, the investigating authority has specifically mentioned the steps taken in order to ascertain the authenticity of the documents.
Tell me the gist of this. We are the petitioners here, huh?
Two petitioners.
10 persons appeared, one has already been charge sheeted.
But the conclusion is that, my lord, eventually, after ascertaining all the materials and after sending all the notices to the concerned sports disciplines, my lord.
Do you have a copy of this?
I don't have mine.
See, during the course of investigation, the certificates of Rakit Dolam, Ralung Ringom are found to be genuine as per report furnished by the
Yes.
Then what more is there?
That is the end of the matter.
That's the end of the matter. Finished? So Where is your selection here?
My lord, selection is,
I'll only rely on this. I'm
Yes.
only relying on you.
No, obviously,
This one only.
very much.
selection matter.
I'll put it in your mouth.
Page 76, my lord.
76.
And to substantiate those statements, my lord, the enclosures are being made.
Okay.
My lord,
fine,
I-
I'll go by this.
I'm sorry, my lord. गलती लिखा हुआ है। मतलब just a moment, my lord. In my record, I have noted it wrongly.
Petitioners belong to archery and football. This
Football, my lord. तो रिजल्ट कहाँ है? नहीं है ना। 74, my lord, is the, my lord, call letter. Thereafter, my lord, 76 is the notification for appearing before the selection board.
What happened after that?
We duly appeared thereafter, this was ceased and no result has been declared. That is the thing, my lord.
Okay.
There is no short list.
So we'll have to ask them to now take the matter forward from
Yes,
here,
yes,
right?
yes. We have already appeared, they have to declare the result only, man.
Declare, results have not been declared.
Not yet. On 15/9/2020, my lord, 10 candidates appeared. The call letter is at page 76, man.
Call letter is at 76.
76.
And where is the list?
List has not been declared, madam. We appeared on 15/9. Thereafter, the FIR was lodged on 25/6. That is how it remained. Results have not been declared.
Okay.
The selection process otherwise is completed.
Heard Mr. D. Pani, learned counsel for the petitioner, and also Mr. T. Sering, learned additional PP. Mr. T. Sering.
J. Sering.
J. Sering, sorry.
Yeah.
Sorry, J. Sering,
SPP for this.
PP.
Okay.
PP.
Rejection list नहीं है ना?
As in terms of the order dated.
Hmm.
30/11/2023, placed before this court a status report from the investigating officer in the case of, what is the case number? CB-PS C/number -0721 under section 420, 468, /471, /34, and therein has content that the certificates relating relating to the sports discipline involving the sports discipline wherein the petitioners have submitted their applications were found to be genuine as per the reports furnished by the local sports associations. Also, in view of the above position, hearing is concluded. List this matter again on
Yes, ma'am.
on 12/3/2024 for delivery of files. I'm just retaining it, I'll give it to you.
Right.
The status report as furnished by Mr. Sering, Lanet PP, is kept on record. Place this matter before any other court without me. मेरा नाम लिख दीजिए. Hello, 15. Yes.
Lordship, this writ petition is filed for re-verification, and reassessment of the land of the petitioner.
But Mr. Rattan had taken a plea here
Yes,
on 13/12/2023 that your affidavit and the pleadings
Yes.
don't match.
yes. For that, I have reply, Lordship.
Hmm?
I have a reply, Lordship.
Hmm.
Can you see
Hmm.
this? Particularly with that particular point.
No, how can you support a statement of 29 with an affidavit of 18th?
Lordship, in this case, that is not the fact, Lordship. Fact is otherwise.
No, no. Clarify this because the
Yes,
court had raised the.
I'm
He
clarifying.
may be wrong.
Yes. Kindly see page number 22, affidavit, my affidavit,
Hmm, I'm with
my affidavit in this.
18/9.
18 September, not
Huh.
18/9, 18
18
September,
September, huh?
18 September 2018.
Hmm.
This affidavit was signed. Affidavit was signed before the court, but due to some lapses in the documents, the matter was not filed. That was the case. And later on,
See, your
All-
para 12 onwards, even that before that.
18 September
Para
2020.
11 onwards is not verified. Cannot be said to be verified. Because on 18th, you could not have verified a fact of 27th, 9. Come to page 14. Para 11. And those are vital statements.
Para 11 of WP.
WP.
Para 11 of This is with regard to
That-
chatting,
Huh.
27, this is with regard to 27 September.
Huh. And
And
your affidavit
this-
is of 18 September. Yes, Mr. Rattan. What do you say?
Therefore, my lord, the writ petition
This cannot be
cannot
sustained.
be
Mr.
accepted, my lord.
You should have amended it. Even
Tomorrow-
now, the amendment also will not work because the affidavit cannot be changed.
Tomorrow, matter may be fixed for tomorrow, Lordship.
Why? What
I will make a preparation, Lordship, and if necessary, I will file.
No, amendment will also not
some
work here.
Necessary
Mr.
rectification.
Mr. Counsel, the amendment will not work for the simple reason that the amendment cannot, either you'll have to remove
Even
these
if-
paragraphs,
Even if this particular point is dropped, Lordship.
it cannot be
That-
dropped. Because I cannot take cognizance of that because your affidavit does not support it.
That is why,
See,
Lordship,
a writ petition, we don't have any evidence. We go by this only. The affidavit is the one. Affidavit, see, you have shown these pages as matter of record, 11, 12, 13. And that record is of 18/9. Whereas the contentions pertain to incidents after that. It may
This is-
happen, it happens.
this
but-
is, Lordship, this is with regard to a representation, pending representation.
Be that
This
as
is
it
a
was,
statement.
bring it on record.
Statement with regard to one pending representation. Matter may be fixed for tomorrow. I will take necessary steps.
We'll have it on 12th.
12.
On the prayer of the learned council for the petitioner. Let's just matter again on 12th, 2020. Let him see
My
what he
lord,
will.
there shall be no bar for disbursement of the compensation.
We have not barred you, have you? Then why should I just come in? You proceed.
Always.
My lord, in this matter, it was fixed for submission of written argument on behalf of the.
Written arguments. Huh.
So I'm submitting.
The respondents have already brought their note on record.
Yes.
Okay. The learned counsel for the petitioners have submitted their written argument in the matter. Accordingly, hearing is concluded. Matter stands reserved for judgment.
Most of them.
Item number 17.
Yes, respondents You're not filing affidavit?
Your Lordship, on the basis of earlier order, Your Lordship, they have written the DC Anani was to be made party, but they have made DC rowing. So we send a notice to the DC rowing.
DC rowing is not
Yes, Your Lordship.
My lord, I have already corrected.
corrected.
the road.
Yes, it has already been collected, Your Lordship.
Yes,
So
We may be,
it's corrected way back on 7/11.
yes.
yes, Your Lordship.
So you have your instructions from the proper authority.
Extra copies may be furnished to us, Your Lordship.
Why should we come in? Doesn't look nice. Saying in the order extra copies, that's the council's duty to do it. At least I did not like it when I was the other side.
Yes, ma'am.
The court directing me that extra copy. Why should the court direct? You should give. Give it.
Yes, ma'am.
Seen the office note dated 2/3/2024. The service report upon respondent number 5 is still awaited. Mr. So-and-so, additional senior government advocate,
No, Your Lordship, junior government advocate.
junior government advocate submits that he be granted for the 3 weeks time to bring on record the stand of the respondents number 1 to 4 by way of filing an appeal. Prayer allowed, list this matter after 3 weeks on a date to be fixed by the registry.
Much obliged.
Give him copies. Await service on respondent number, or seen the office note dated 2/3/2024. Await service of on respondent number 4. List after 2 weeks on a date to be fixed.
Here, they deliberately they are avoiding the service, maybe, my lord. So therefore, in that additions to that, my lord, I may be allowed to take dusty service upon the
Full stop. The petitioner is permitted to take service of notice upon the respondent number 4 by way of dusting,
my lord.
routed through the registry of this.
My lord.
Full stop. Thereafter, the petitioner is required to file an affidavit in the matter. Thereafter, upon effecting such service, an affidavit be filed by the registrar by the petitioner in the matter.
My lord.
A list after 2 weeks. 2 weeks on a date to be fixed by the registry.
And my lord, other respondent is, my lord, the state respondent is also not filing affidavit, my lord.
You file, first you complete this.
The privilege. My lord, there is a interim order, my lord, subject to outcome the privilege.
May it please your Lordship. Madam, there are interlocutory application that has not been allowed in the main petition. In main petition, there is a review petition. I'm sorry.
May I please, Lord? My lord, this is a restoration application. In this case, for restoration of writ petition number 416 AP of 2015, which was dismissed for default on 30/8/2022, my lord.
Dismiss on default after waiting for 2 days. Right?
My lord, I have explained in there are 3 of my petition, my lord. Page 4, my lord. My lord,
Okay.
there are 3 of
I will restore it.
my lord.
When will you? Here.
My lord, next week, my lord.
15 minutes.
15 May, my lord.
This is item, this is case of 2015.
Yes, ma'am.
8 years.
Yes,
We'll hear it on 6th. Subject to that condition, we are restoring this.
I'm obliged.
But the learned counsel for the applicant, oblique writ petitioner, and also had MS so-and-so, learned counsel appearing for the state respondents. This application has been instituted by the applicant oblique petitioner, praying for interference with the order dated 30/8/2022 by which the petition being WPC number 416/2015 was dismissed for non-prosecution. Full stop. This court has perused the justifications for appearance by the counsel as laid out in the application and finds that the same is satisfactory, and accordingly, the writ petition is restored to the file, subject to the condition that the petitioner shall make, the petitioner's counsel shall argue the matter on 6/3/2024 for final. Argue the writ petition, connected writ petition for final disposal on 6/3/2024, right? Main case mein aaye. In view of the order passed today in Miss MC WP 1 AP 2024, the present writ petition stands restored to the file. Full stop. List this matter again on 6/3/2024 for hearing.
Obliged, deeply.
Matter was fixed now. Hearing.
Obliged, deeply.
But 6, please don't take time. If you take time, it's all recorded here now. I'll dismiss it. I'll dismiss it on merits.
Maybe.
My
lord, petition, review petition has been filed under section 100.
Show me the error. What error did this court make in passing this order? When you yourself submitted.
But that was already misled by some other
Now
person.
tell me, who is this person here? You have made, yes. Come to page 8.
Yes.
Page 8. Page 8 of your application.
There is a 550 days.
No, third line. Forget the delay. We will consider delay. Come to the third line. Page 8, third line. Page 8. Just above paragraph 4. Got it?
Yes, ma'am.
Come to the top, third line.
Therefore, due to misleading and false representation on the part of the informant.
Who is this informant?
Through telephonically they have conveyed that this person, he has already got the relief because land compensation has already been paid to the government.
No, you have to clarify who this informant is. And how could you act, Mr. Counsel, on an information given to you by others other than a person who is not a petitioner? You have not said that.
Yeah.
How could you act? Because see, this has some connotation. How could you act? Because you can act only on the instruction of the petitioner. And the order says, instruction from the petitioner.
As per the telephonic information,
From the petitioner.
Yeah.
You have not said so. You say informant. Who is this informant? Is he the petitioner? If not, why did you make a wrong submission?
He has instructed that he has already received the amount.
Who? Petitioner.
Some
Was
other
that
person.
telephonic instruction from the petitioner?
Some other person.
Then why did you make this submission? You come to page 18, that is not the submission. How can we believe you today?
Yes, my lord. That is a fault on the part.
This is serious. Because here you say instruction from the petitioner. You don't anywhere say in your whole application, I've just gone through, maybe I missed out. If I missed out, you give me the clarification that it was not the petitioner, but somebody else who misled you. You have not said that. And if not somebody else, who is that somebody else? Because we'll have to proceed against him. Yes. What do you say? Because the order says instruction from the petition. Here you say informant. Who is that informant? Mr. Son, there is no problem for me in reviewing this order. But this does not look good. Yes, Mr. Soikia. Require your assistance. There was a case file which was withdrawn with the stipulation that the petitioner had instructed the council not to press the matter. Accordingly, this court dismissed as not pressed.
Close the case.
Closed. Now, an restoration application is filed in the form of a review petition saying that due to misleading and false representation on the part of the informant is not disclosed. What should this court do in such circumstance?
Has not been disclosed, but actual action should have been against the council concerned.
Council maybe have misled. Council was misled, maybe, but he is not even saying that.
Informant, who is the informant, that has not been spelled out. And normally that sometimes happens because of the miscommunication. The client says something and we hear something and submission is made.
Now you declare who this informant is, Mr. Son.
Well, I'll definitely file with affidavit.
You file?
Yes.
No, you file an additional affidavit.
Yes.
Who that informant is? Because again in the grounds in clause 2 you have said, for the action on the part of the informant has given a false and misrepresentation to the advocate's clerk and the learned counsel against the petitioners was due to jealousness and envious. And you also explain how could you have acted on an instruction given by a third party. Take adjournment, try before somebody else. If I have to enter, I will be entering in a very bad way. On the prayer of Mr. T. Son, list this matters again after 2 weeks on a date to be fixed by the registry. So this, otherwise it's serious.
But
It's
my lord,
misleading the court.
my lord, in some cases, my lord, in such cases,
Mr. Son, because if I do something, it may cast an aspersion on you. That's why I'm keeping my hands off. But never act on an instruction given by an authority other than your petition. You cannot.
Yes, ma'am.
You're legally prevented from doing that. Yes, Mr. You cannot. Happens sometimes, I know, but no. Such situations, you will be in trouble.
Actually, what is the accurate information given by the
I know
other
Mr.
person?
Son that he was misled. That much I can say. But I can't take judicial notice of that. Try your luck.
Similar matter, just the item, the similar matter today, we are having the BC, RBC before Justice Surana matter.
This matter?
No matter, the same matter, the first one matter.
Okay.
In that case, same case. In this matter also, the BC is going to be conducted. In this same exact nature of the case is very similar.
Mr. Son's matter.
Yes. Withdrawal has been made by some council. The other council has come and filed.
Here, Mr. Son is reports. That much. We know Mr. Son was misled. That much I can say. But see, that issue is very serious. Yes, Mr.
But I have filed this, for a direction to release the pending bills without deduction of the damage, alleged damage from the bills. And
I think you will have to come back once more, Mr. Okay. We will issue a notice here and I'll give you a reason for that. I don't want to come in at this stage because this is a prayer made by you, serial number 3, page 33. So that will be giving you a final relief.
One of the final relief.
One of the final relief.
At this time,
So that is the basic relief you are claiming in the writ petition. In addition to release of that bank guarantee.
Before that, I would have prayed one thing can be a joint verification because
we'll not do anything because we want a affidavit from them. Let the affidavit come.
No, that will be an independent.
Naturally, a joint verification
No, in fact, my lord, your lordship will find in the, my lord, page 138 of the writ petition, they themselves has, my lord, sought for a, my lord, joint verification with the, my lord, principal contractor. But then principal contractor
He is gone.
he's gone, my lord, and the whole entire work.
What happened to that matter, Mr. Girindeka? What happened to that case? Finally?
Girindeka, the
Learned single judge
single
allowed.
judge has allowed, my lord, basically taking that it was an assignment, and then
Yours is a better footing.
yes,
Yours is a much better
much,
footing than
much.
Girindeka.
Yes.
Girindeka, there was nothing.
Nothing, my lord, nothing. But an interpretation, my lord, has gone that though it was a.
You are on appeal in that case.
I am appeal. There is an stay on that, my lord.
Stay has been granted.
Stay has been granted.
Section 70 contracted.
Yes, my lord. They had relied on that, my lord. But here, my case is squarely covered by section 70. This particular case, my lord. Now, only, my lord, difficulty is that, my lord, their contention saying that 26.1% of the work, which they have, my lord, taken the date as 27th April. That is
No,
the
Mr.
second
Soikia,
milestone.
For my consumption, my understanding.
Gotcha.
See, there is a road 100 kilometers. You have been given a subcontract for 49 kilometers, right? You are only a subcontractor. The payments normally are made to the contractor and the contractor then pays it to you.
That's it.
Right? Here also the
Here little different.
Different, right.
Yes.
Now, for this 100 kilometer, say your due is say 10 crores. But the authority finds that for the 100 kilometers, you did 49 kilometers. For the balance, with regard to that one contract, there is a recoverable amount of say 9 crores or 8 crores. Now, is it not, are the authorities not within their power to not pay you and recover that amount?
My lord, had that been, my lord, stipulated in the contract agreement?
No, yours is a subcontract.
Subcontract, my lord. Gotcha.
The main contract speaks about that. Naturally, we'll have to. So if that be the situation, how do you reconcile?
In the main contract, it has been.
You still have a way, you can recover it from him. Civil suit, money suit, whatever it is. But for the authority, can the authority now see this as two contracts when they had only entered into one contract? Something troubling.
Yes, my lord, because the contract clauses here are very clear, my lord. That any, my lord, default or fault or whatever realizable, that will be realizable from the, my lord, principal contractor. That is there. He stands, my lord, the principal contractor.
He will be
I
the
have
main.
nothing, lordship. Yes. So far as I am concerned, my lord, I did not have any, my lord, PVT of contract with the, my lord, authorities. And my lord, they have approved my subcontract.
Fine.
And the 49% I have executed.
Fine. There is an escrow account, they will have to pay that amount to the escrow account.
Escrow account.
Now, if there is a recovery for the whole contract,
Yes.
what would be?
So first, 51.
So should the contract be now again subdivided into 49 and 51? Okay, 49, Mr. Soikia, he will get it. 51, we are not giving.
Here, my lord,
Now, what if you are trying to say that single contract now has to be treated as two contracts?
Two contracts.
Which was never, because you never had a privity of contract with the authorities.
That's it. But they have, my lord, accepted my lord, work there.
Fine.
They have got my work
Fine.
there, my lord.
To that extent, fine.
Anything there.
And see, they are not bound to pay you also. They are bound to pay you through that main
escrow account.
Escrow.
No, in fact, my lord, this matter was raised with them also that the principal contractor is not paying me. And they have issued also a letter that you pay him. So to that extent, but they have not, my lord, executed that particular, my lord, direction issued by them, my lord.
See, that would be a dispute per se between you and the principal contractor, whether it would be maintained.
My lord, here, my whole contention would be, my lord, the authority has a contract with the principal contractor for realizing all the amounts. So far as I am concerned, my lord, it has nothing there, my lord.
No.
With me, my lord.
You are again behind him. The main contractor is the one facing the authority. You are there. I'm not saying that you are not there. You are behind him. Now, if there is a recovery made to be made from the principal contractor, can the authority segregate 49, 51?
Here, things so happen, my
So
lord.
if for any payment made for 51, we will affect recovery, but 49 we are releasing. That cannot be because work is one.
But so
This is
far-
something
no,
troubling.
So far, well, that's one minute. So far as the subcontractor is concerned, well, there is no condition that anything payable to the subcontractor, if my lord realizable some certain amount remains to be realized
See,
from the principal contractor.
Payable to the subcontractor, not by the authority, but by the contractor. By the principal contractor. For your convenience, an escrow account was created. That's a different thing altogether. Amounts were being paid because principal contractor required the authorities to pay to that account. Now, if there is a recovery, what would be the service? Kindly.
Yes, my lord.
Kindly.
My lord, same, my lord, what I'm on, my lord, this section 70 of the contract, I'm taking into it. There, my lord, the contract is not required, my lord. There may not be any agreement also, but
No need.
but thing is that is some sort of, my lord, unjustly enriched concept, my lord.
Now we introduce a spoke to that. Section 70 says if you have done some work, you get the payment. Right? Now, I, the contractor, the authority, have given him a work. He has engaged you as a subcontractor. Now you are entitled to your part. But the amount that you are entitled to, more than that, I have to recover from.
But
Am I not entitled
in this
to
case, my lord,
because otherwise, this is public money.
Public money. My lord,
How will I have a recovery
No,
from
my lord, here distinction is that from the day one of the contract, my lord, the 49 entirely left for me. I have been
You have
exhibiting
made
for
statements that this were being done by you and the authorities were also examining the work through you only.
My lord, they have not denied that I have, my lord, done this, my lord, work, my lord. They have not denied, my lord.
I'm very much with you.
That's it, my lord.
You have done the work and there is no complaint with that.
49% I have worked, my lord, though they have not denied, but in the paper, what they are maintaining, my lord, 26.1%, that is on 27th April of 2023, that is the second milestone. They have not taken, whereas, my lord, the principal contractor also has submitted sometime in July, saying that 49% of the available work has been executed by, my lord, me, my lord. And they have not taken assessment of the subsequent work because the UOT that was submitted by the principal contractor has been rejected. Extension of time. Now, my lord, my whole, my lord, situation, your lordship will see, my lord, from day one, everything
You have invested.
I have invested. And they are the, my lord, Union of India or the BRO, my lord, they have the entire, my lord, mechanism to realize the money from the, my lord, respondent number 6.
That is my question.
I am a local contractor invested
whether we can direct them to do that. Show me something. This recovery on the part of the authority, can we direct that this will be minus what is to be paid to you?
The subcontract, that particular clauses, whatever is prevailing here, my lord, it says.
Subcontract is between the principal contractor.
No, not subcontract clause in the contract agreement between. Yes, my lord. That I have quoted, my lord, will find. In the writ petition, lordship,
You have not filed an affidavit till now?
Filed.
In main case, we have filed.
They have filed.
In IA, I'm instructed to file it.
My lord will find this clause only, page 12, 4.2. At
12
page,
of your
writ petition. Lordship may skip clause 1, that is with regard to 49%. Then, my lord, this second also, lordship may, my lord, skip this. If it is exceeds, then certain criteria has to be fulfilled by the subcontractor. Then, my lord, clause 4 at page 14. It is expressly agreed that the contractor shall at all times be responsible and liable for its obligation under this agreement, notwithstanding anything contained in the agreement with its subcontractor or any other agreement that may entered into by the contractor and
No default under such agreement shall excuse the contractor from its obligation or liability under the agreement. The contractor, if I default.
Read further.
Lodgement.
Oh.
However, in case of non-compliance of contractor towards his obligation for payment of approved subcontractor, which is likely to affect the progress of work, the authority reserves the right to intervene and direct the contractor release such outstanding payment to approved subcontractor.
So in the circumstances also,
They have directed them.
fine, they
Contractor.
have not undertaken that we will make the payment now.
That's it.
The authority will make the payment to you. That is not the clause.
Well, the intent of this particular clause, my lord, lordship will kindly see, my lord, this non-payment directly, my lord, having the effect on the, my lord, progress of the work. Mere, my lord, realization of the amount or deduction, but no, my lord, that progress of the work has to be, my lord, the work has to progress.
Is the escrow account still in operation?
Escrow account is in operation. I have submitted representations that you don't pay it to the escrow account. Because escrow account also he is doing, my lord, because 97%
So 97% should come to you.
come to you. So he with the, my lord, bank, he has, my lord, taken, my lord, a huge amount of what he is entitled, thereby, my lord, more 90 lakhs he has, my lord, taken. So I have given to the, that don't
Yes.
pay to them, my lord.
In your affidavit, what steps have you taken against the principal contractor?
My lord, so far, my lord, no particular, my lord, as per the affidavit filed by the, my lord, respondent department, my lord.
You,
Particular-
yeah, this affidavit, yes.
Yes, my lord.
You have not dealt with anything, you just given a vague,
They have admitted
ma'am.
everything, my lord.
Admittedly, my lord.
They have admitted, my lord.
then you pay.
They have, my lord, they are the, my lord, BRO, my lord, the Union of India, my lord, they have all the, my lord, mechanism, my lord, even if it is in Bombay, wherever, my lord, the offices, they may realize that amount. But so far as I am a local contractor, lordship has seen, my lord. And time and again, I have been representing the authority.
Mr. Kato,
My lord.
your case here is that the original contractor could on a particular date only complete 26.1% milestone, which was much less than what he has to achieve.
Correct.
And accordingly, the work suffered. Within that 26.1, maybe the works of the
Entirely.
entire is with regard to this person. Now, tell me your stand, because the subcontract was also approved by you. Tell me your stand as to why this court should not pass a direction. Directing you to release the amount for that part to him. And in whatever manner you want to recover from the petitioner, from the principal contractor, you are free to do that.
My lord, in that case, my lord, may I pray that, my lord, some more time may be allowed.
No,
so
no,
that
no.
I can come with the, my lord.
No.
My lord, in the
It should not be
affidavit.
it should not be a very, just a formal exercise.
My lord.
We'll record it to file an affidavit to that point.
My lord.
Right, Mr.
Yes, my lord.
And
I've
my
received the instruction, my lord, in such position, my lord, termination has been made as per the contractual agreement, my lord.
Because even he can't go for an arbitration.
Correct, my lord.
We don't have that.
You
problem.
don't have.
Correct.
And
So
my lord,
therefore,
if-
my lord, by my lord, the instruction, my lord, I'm instructed to file an application, my lord, the reply.
This we are not considering.
Yes, ma'am.
This is just there. This
Well,
is only going as an appendix to this.
Yes, ma'am. I'll come with
Because
the
it's
clear
already
affidavit.
there in para 3.
I'll come with the affidavit that, my lord, clear instruction.
Let him come.
Another aspect you'll also will see, my lord, this 27th April 2023, this is the second milestone date. We have violated that. For a moment, we have violated it. They did not stop us from executing the further work. So thereby I have progressed my work. At no point.
According to you, taking the work you have done, what is the quantity of work completed but till now?
But so far as, my lord,
Not you, the whole work, in the context of the whole
whatever
work.
I have done, that is the works.
No.
Lordship, my lord.
In the context of the whole road, say 10 kilometers.
10 kilometers.
So how many kilometers have you completed?
My lord, it's so far as, my lord, the total amount is something about 67 and odd crores, my lord. Out of that, 20 crores they could not, my lord, clear. They could not approve what of the work.
Around 47 crores.
48 crores and odd comes. Out of that, I have completed 49.8%.
Out of that 48.
available scope of the work. So therefore, my lord, at this stage, my prayer further would be, my lord, let there be a joint verification as they wanted, exactly how much
No.
work, lordship.
No.
Yes.
That's it. Because moment we pass a joint verification order, that means we'll have to draw a satisfaction that you are entitled to that payment. I don't want to draw it today. Let us have the specific instruction from them. Thereafter, on that same day, we will pass this on.
Because they themselves has undertaken, but with my lord Velacha, who is my lord, not in the scene at all, my lord. The page 138, lordship, may kindly,
This is a common problem with this
Gotcha.
work now.
lordship, may kindly see the, my lord, page 138, my lord, this, my lord, address to the, my lord, respondent number 6, please refer termination notice issued so and so, so and so. It is requested to deputy or authorized representative for joint valuation of the unpaid work to be carried out with effect.
See,
on-
Mr.
Lordship, my
So, okay, even if I permit this,
Gotcha.
still there will be recovery.
Yes, my lord, that will be again, my lord.
That will
yes.
be again more than what you are entitled to.
Gotcha.
So that will be a futile exercise because even after doing this, you will still be not able to receive payments until and unless we hold
Gotcha.
that you are entitled directly to receive that amount.
Gotcha.
So let us have this. On the heard Mr. P.J. Sehgal and counsel for the senior counsel for the petitioner senior counsel assisted by Miss Huh? M. Nirola, learned counsel for the petitioner, and also Mr. M. Khato, learned deputy SGI, appearing for the respondents number
124, madam.
124. Madam, Mr. So-and-so, Ms. So-and-so appears for respondent number 5. None has appeared for respondent number 6.
6 and 7, madam.
7. Full stop. Nahi chahiye. Full stop. Mr. Khato shall file an additional affidavit on behalf of the respondent number
124.
Bureau authorities.
1 to 4,
1 to 4.
highlighting as to why the payments for the work as done by the petitioner as a subcontractor, comma, duly approved by the authorities, comma, shall not be released to the petitioner directly after conducting a joint verification of the works, joint verification of the part of the work as executed by the petitioner. Find anything more?
That will do.
List this matter again on when?
Madam, after 2 weeks. For filing affidavit, madam, at least it will take time. Or 3 weeks, madam. 3 weeks time may be granted, madam. Will come with the affidavit. To that extent. Otherwise, the rest I have already received, madam.
So Swiggy will try on 20th. 20. If you have any difficulty, tell me.
Can you 22nd in the case?
22nd.
22nd.
List this matter again on 22. 2024.
Well.
But don't delay. Because this person, if he is not entitled, we hold. He'll also have to explore other options.
Well.
Because he's a small contractor. His whole thing has been invested in. Capital has been invested in.
There is interim order that can be extended, my lord.
Ah.
It is with regard to the, my lord, PBZ, my lord.
The interim order passed earlier shall stand extended till the next date of this. PBG has been.
Debatable.
May I pray, my lordship?
Yes.
This matter will be listed day after tomorrow, my lordship.
Why?
And this, Miss Giete, she'll be appearing, my lordship, and she had some personal difficulties too.
Yes. What is your case?
My lord, item, I
On price, item number 24, I'll press for item number 25. Basically, item number 25.
Case number?
Case number 17 of 2020.
You don't want to press it. You want to press that.
Yes.
17.
Now, for that, I need to obtain instruction from my client.
No, what do you want to do us today?
Now, case number 475 of 2019.
You
I don't want to
press
press, yes.
Huh?
Yes, I don't want to press this matter.
We'll close it.
Not close. For that, I need to obtain instruction from the
Why?
client. Day after tomorrow.
What is the matter today? Hearing. We'll hear it.
Yes.
Both the matters we'll hear it.
But actually, my lord, in this matter, I am newly entered. Earlier, there was a different counsel previously. So I have a brief of 17 of 2021, item number 25. Both are different issues.
One is promotion, one is pension.
Yes. my lord.
When she will be available, ma'am? And when it will be convenient for you to argue, give us a date, convenient to yourself.
Otherwise, my lord, in the meantime, I will file a rejoinder on their affidavit. So 14, on 14th of this month.
14th.
Yes.
On the prayer of the learned counsel for the petitioner, list this matter again on 14/3/2024 for hearing.
In the meantime, I will file.
Petty parties are at liberty to bring on record pleadings, if any. Item number 3.
In item number 17, 26 only, my lord.
But we have said both. दोनों में एक ही order. Item number? कोई नहीं. Who is appearing for the government here? He was supposed to appear through online, na? हम बोला online appear through. देखा जानता है. On the prayer of Mr. U. Dekal on a counsel for the petition and list this matter again on come. हम 15 तारीख तक है उसका पहले एक डेट 12 on 12/3/2024. Ma'am, please inform Mr. Nama.